Yes. Our court is, it is being, proceedings are laid online. Therefore,
this order, my lord. My lord, the ground, my lord, without going through the merit of the case, is simply directed to the petitioner, giving liberty to file a fresh repetition, my lord.
What was your grievance before the learned single judge?
Grievance, my lord, the petitioner grievance is, my lord. Petitioner is continuing as a teacher, my lord. Teacher, drawing salary, my lord. And the area salary of some intervening period, my lord.
For what period arrears to be paid?
That is, my lord.
94 to 2007.
94 to 2007.
94 to 2007.
My lord.
When did you ask for payment of the arrears of the salary?
Official, my lord, the
date, year.
Yes, my lord.
In which year you had sought for payment of these arrears?
Just
answer our question.
My lord.
We'll hear you. Because Supreme Court said, while claiming money from the government, ordinarily the limitation prescribed under the Limitation Act 1963 schedule has to be adopted ordinarily, although writ proceedings are not governed by Limitation Act. But the idea of delay in latches will come in. Therefore, we are asking you, when did you for the first time ask your employer, give me the arrears of salary? Which date?
That is in the year 2000.
Which page? Which paragraph?
Page, that is my read petition that has been mentioned, my lord.
Mentioned.
In here, my lord, but not mentioned, my lord. In the
how?
Sir, he says in the appeal he has not mentioned.
No, in the petition itself. In your original
you are not having copy of the
read petition. No? I have copy.
So kindly refer. We are having some copies.
Which paragraph you have on?
Read petition. Okay.
Yes.
Your lordship kindly glance the page 6, 6.6, man. Earlier you approved to tribunal, man.
Read.
6.6, man.
You went to administrative
tribunal.
Okay. In that pleadings of the tribunal, what have you mentioned again?
Pleadings, my lord. That is, my lord, 6.6, paragraph 6.6.
Read paragraph.
And when respect order passed in the content of applicant's salary was not paid, he filed another content application during 17 was such and such. Alleging violation of order passed by the Honorable Court, aforesaid content application that is 17 was such and such to comply with the order within a period of 3 months from that date. After dispel of the said content petition, state government by virtue of order dated 22/8/2009 directed the Director Secondary Education with a copy to the Inspector of Schools Khorda Circle Khorda to remove the applicant without any notice on the ground that he produced a B.Ed certificate from the Varanasi Sanskrit Vishwavidyalaya Varanasi, which is a fake university.
No, that's not, you are not on the question. You are going on narration. Question answer, it admits only binary answer. I asked for the payment of the salary on such and such date. My letter dated so and so. Where is that pleadings? You want to prepare more and come back?
Let's see.
You come back on. Gather your thoughts on these questions and you come back. You take a short adjournment
if you want to. We are not telling you.
Just I am submit 1 minute. If you lost your
these are all 1 minute cases only. Question is payment of money. Salary is your property. But you can't ask for the salary saying that I had worked when Alexander had come here. Now they have to make payment. That we cannot do. Therefore, you have to tell on which date money was payable to you, salary was payable to you, on which date you paid it. That's the case of mandamus. For mandamus, there should be demand and refusal. This is what we have been taught in the law school. Do you agree with this? On which date you asked for payment of arrears? Please answer that question.
That is prior to filing of the original application before on a tribunal.
You had filed the application on which date?
On which date that is my lord.
2nd of February 2022.
2nd February 2022. So that will be from 94 to 2007. I think you have to give concession to the shortness of human life. At least learned single judge has said, make a representation, let them consider. In the event representation is rejected, we'll have a fresh cause of action. Then you can come and complain to the lead court. Otherwise, we are not finding any.
Yes,
nothing. Why, brother? Why are you not paying the salary? Salary is the product, sweat and toil of an employee.
I'm confused. But so far, this impugned order is concerned. Only the finding is what my learned this honorable court has rightly pointed out. Only they have to file a representation stating entirely all the facts, and within a period of 3 months, it has to be disposed. Then this matter is this order is impugned in this writ appeal.
All right. Whether similarly circumstanced employees, did you make payment? Right to salary. We are not East India Company. If I want, I will pay. If I do not want, I will not pay.
That period is, some period is untrained teachers. Then some period.
Yes, brother. We are not finding.
Yes, ma'am.
We'll make an order saying let them decide within 3 months. And thereafter we'll have fresh cause of action.
But I am submitting to Lordship.
So
petition is going to return my lord.
From today's
Very well.
From today's discussions, since when a lot is to be answered by you, at least the court has given stage of safety. When supplied oxygen, everything, now you are when
you can resurrect, you can resurrect like Phoenix.
So let them take it.
Let them decision.
No, but I think that
3 months, they will take a decision. If you are satisfied with the decision, no problem. If you are dissatisfied,
Exactly the finding of
you will
the
challenge.
announcing judge.
Okay. That's the finding, na?
That is the finding.
Please be seated.
When it is not
Please be seated.
the other part is that the order is not against you.
It's not kind of in your favor. Please be seated. This intra-court appeal seeks to call in question a learned single judge's order dated so and so, whereby appellant's petition number so and so has been negative. First of all, next paragraph. Learned counsel appearing for the appellant teacher vehemently argues that in the fitness of the facts, learned judge ought to have endorsed the answering respondents to release the arrears of salary that have accrued due during the period between 1994 and 2017. And this prayer having not been favored by the Orissa Administrative Tribunal in application number, sit down and say, this is not a primary school. Sit down and speak. Sit down and speak.
That is transferred to this honorable court and renumbered as a WPC number, WPC OSC number 1073.
First, submits that salary payable to an employee is a consideration for the blood and sweat he puts in during the course of employment, and it is more so when the answering respondents is an entity of the state under Article 12 of the Constitution of India in the light of R.D. Shetty versus International Port Authority, so and so. First one. Therefore, he seeks a positive direction to the respondents after setting aside order of the learned single judge which has reserved liberty to the petitioner only to make a representation claiming the subject arrears of salary. First up, next paragraph. The government, what do you call as? You are called as additional government advocate. Learned additional government advocate, on request having accepted notice on behalf of the answering respondents, be seated. opposes the petition, contending that in a law of mandamus, it has been well settled that there has to be a demand and refusal, and this having not happened, there was no cohete, CHOATE, head of action or the employee to knock at the doors of tribunal or the writ court. First, he also adds that the learned single in the facts of the case has permitted the employee to furnishing all relevant facts and factors coupled by evidentiary material, and that the said representation, if made, would be considered within a period of 3 months. First off, this, according to the learned government advocate, does complete justice to the employee in appeal. First off, we are in agreement with the same. First off, in the above circumstances, this writ petition is disposed of affirming the order of the learned single judge. First, okay. All contentions of the parties are kept open to be considered in the contemplated representation. First, courts made easy. Yes, next.
Only 2004 to 2007.
We are not entering into that.
They are saying 2004 to 7. 2004 to 7. But they have said that 2004 to 7. Yes.
No, 2004, not 4 months.
We are not. Mother has said it rightly. 1994 to 2007. 1994 to 2007. That way it changed. Very good. Item number 2. Yes, sir.
Petitioner is a nursing college, my lord. Applied for the,
what is the order that you want to?
He applied for the renewal of the NOC.
Renewal of?
NOC, no objection certificate.
Under which act?
My lord, that is on the ONMRC under the
provision. Which act? And how courts viewed that provision? How jurisprudence is developed on that?
Here my limited prayer is, my lord.
Your limited prayer I don't want. We want under which act there is a prescription of NOC and you had applied for one and that has not been granted to you.
My lord, that Odisha Nurses and Midwife Registration Council.
Can you prepare and come back?
My lord.
We'll give you time instead of wasting our time, your time. Can you come back after reading the papers? We are asking you under which act?
Annex 1 is the last year renewal, my lord.
No.
You are not answering. Which statute?
Mr. Pani, you have not even referred. As per the High Court rules, you have to refer to the statute and acts and in the constitution. In the matter of so that no difficulty, you can come back tomorrow or day after.
You prepare and come back. Suppose if you perform well, we cannot deny relief to you. If you do not perform well, all the people will be looking at you and looking at us also. That we have our online.
But
They should consider.
See, limited prayer has unlimited consequences, Mr. Pani.
Pursuant to application, they have already made inspection of other colleges.
We are asking you the foundational facts. Which law requires the process to treat the claim in NOC? These are the 2 questions. This is what Tangamaidu said in Supreme Court. Tomorrow? Okay. Call this matter to
Lord Senior is appearing for the council. I have already served a copy on him.
Unless you convince us, we will not issue notice. This is a writ court. Therefore, make your case and you get an order from us. We are very, very inclined to grant relief to the citizens because nobody comes to court with happiness. They don't come here with joy at heart. They come inevitably to the court. For before denying relief, be cautious. Just call this matter tomorrow at the request of counsel appearing for the petitioner. Just next.
Item 3 also similar to my Lawrence Senior's case, grant of NOC. Since your lordship has put a question, I have taken up tomorrow. The act is used for what
same order. Next. See, we have a small request to you. This is a court of law. This is a court of law. This is a constitutional court of law. When you come here, you have to state the facts from which your rights arise. Rights arise under statutes, under contract, under precedent, under custom, or loosely under opinio juris. Nothing beyond that. With that full preparation, you have to come. Otherwise, you will not get justice.
Can you take a day after tomorrow?
All right. Call day after tomorrow at the request of learned counsel appearing for the petitioner to come with more preparation. Yes.
Both the matters can come.
We have passed out. Day after?
Day after.
Call day after. Yes.
Don't go.
Yes, sir.
Well, my lord, the state is in appeal.
State is in appeal. Okay, this is a intra-court appeal.
Intra-court appeal.
Since I am fresher to your court, I'm just asking you, what is the scope of intra-court appeal?
My lord,
Which section?
that I have mentioned, made a mention, my lord.
Show that.
My lord, that the first case, my lord.
You can tell it. Which section we are asking?
My lord, under Article 4 of the Orissa High Court rules.
Read. You have to bring your books also. Today, all right, we'll give you.
Sorry, my lord.
You have to- See, toolkit has to be brought to the court. Toolkit, what is the statute? How courts have interpreted rulings? What is the commentators have said on that? How this court has taken the view? What the Supreme Court has said? Both are absent. What are said? This is how practice has to be done.
By that academically will be also sound.
You have to be.
Legally.
You have to be, na? That helps you. That helps you. You are not only judged here. We are judging the cause. We are judging the candidature for various appointments also. Understand? We are judging the cause of the client. We are also assessing your performance level, your candidature. Okay?
You have
not answering the question. But But books,
henceforth.
No, I'm telling you, there is one shloka which says, Pustaka vanita tam prahaste tam. Book vanita, I need not mention. With Shiva, with money. If they are linked to somebody, they are gone forever. Anyway, you will not do that. We know. Yes. Read. Which is the provision?
Under Article 4, Clause 10.
You are referring to page?
I'm the book.
Page, same book we are holding? Page?
This is a.
You have taken our book?
Yes.
Yes.
Which
Refer to the
page?
page.
Page number of the
Page number.
How the scope is determined by which decision of our High Court. We will also come after reading. Now come to the points.
Sir, my lord, the main crux of point. Petitioners, the writ application, they are all contractual, job contract employees. All the way their prayer was for regularization and for pensionary benefits, that period of contract period that may be considered for the qualifying.
That is for pensionary terminal benefits.
Exactly.
They have retired now.
They have retired.
All they have retired.
Yes.
How many years of service they had put in?
They had put in, they have joined in service. The
70, 78
Yes.
on daily wage basis.
Yes, ma'am. Entry into the service under the servant settlement.
Servant
settlement as OMIL.
Means
The Survey Settlement Act contemplates survey.
there is such an act.
Yes.
Yes,
Sir,
Survey settlement.
settlement.
Okay.
So they do survey.
In the
Groundwork
revenue
of survey.
law.
Okay.
Chairman, I mean. But Mr. Mahanti, you are introducing the, I mean, in a different way. You should say that they are getting pension.
Are they getting pension?
No, my lord. Fact
They are-
means they have to consider that period.
No, we have understood now.
You straight away answer the query, court's query.
Are they getting the pension now?
Yes.
They are getting.
Yes.
Now, grievance is, 1 second, you want to know. Their grievance is, the quantum of pension should have been more.
If at all.
That would have happened if you had counted
That
their contract period.
Exactly.
What the law says on that?
No, my lord.
Then you said 1928 they gained entry to the service.
Exactly.
All right? 1 second. 1978 only?
And came to the regular establishment in 2012 only.
2012.
And retained.
Is there any statute, state enactment which provides for regularization of services? No. This is like Uma Devi, etc.
Here,
Umadevan
the state has a policy by notification.
Okay.
Bharatiya 12493.
बार चर्चा ने भी 15,597.
You are seeking too much of assistance from the court. Actually, I will assist you. My lord will
And
assist you on
in
law.
this particular matter, Miller, one matter in Nityananda Biswal's case, it has been gone to the Honorable Apex Court. And subsequently, it has been decided. But recently, just in the month of...
No, even in, please, when the my lord asked you that what is the provision, first is that their regularization. There is a policy,
State
has
policy.
been notified, and if they qualify in that, then regarding pension, you have to refer to the pension rules.
Pension rules.
What the pension rules say?
Pension rules 18, Miller.
Pension rule 18.
18.
Read. Read 18. Take out pension rule. The Supreme Court said in two matters. One, Deviki Nandana Mishra versus State of Bihar. Another is DS Nakara versus Union of India. Pension is not a bounty. It's a right.
It's right.
It's a right. How can you deny that? Which rule 18?
Miller, rule 18.
Read.
Conditions subject to which service qualifies.
Is it 1.8?
1.8 you are referring.
One.
Okay. Read. Service does not qualify for persons unless it is rendered in a
For pensionable
establishment post.
pensionable establishment.
Is it a pensionable establishment? It is. Because you are paying the go to the other conditions.
The entire continuous temporary or officiating service under the government without interruption in the same post or any other post shall count for the purpose of pension in respect of all categories of the government except in the following cases, namely,
in which your case falls.
My lord, I'm in 1-3.
1 and 3. Period of service in a non-pensionable establishment. Why 1? 1 is paying the pension already. Therefore, 1 is not available to you.
First part is non-pensionable.
Yeah.
Second part is pensionable.
Huh?
So actually, what that's a kind of thing at 4.
Notwithstanding anything contained in sub-rule, government may, by general or special order, prescribe any class of service or post which were previously borne under work charge establishment or paid from contingencies to be pensionable.
In 6.
Notwithstanding anything contained in clause 1 and 2, except non-obstant a clause a person who is initially appointed in a job contract establishment and is subsequently brought over to the post created under regular pensionable establishment. So much of job contract service.
in the month of 2012, 14/5/2000,
Superlative.
on 31st May 2012, on the same month. Same month.
Instead of 1 month, I guess,
so much of the fraud contracts shall be added to the trading of this qualifying service in regular establishment and would render him eligible for pension.
so they remain
18. The thrust of Rule 18, pension has to be given. The underlying principle now. Pension as consideration for the past service has to be given. But that is the thrust. To deny
So
pension,
deny pension, these are the
they took
clauses.
a special case under the provision.
Well,
If you read 6, which doesn't
Six.
form,
Notwithstanding anything.
notwithstanding,
This is amended.
whatever is said above,
Yes.
forget that.
Contained in clause 1 and 3.
180. Sub-rule 2.
Yes.
A person who initially appointed in the job contract. Job contract rated has to be on is the mandate of this rule. So they have returned.
in pension.
Have you returned that period job contract?
Yes.
No, they have not.
No, it is not for me.
When I
You show that your contract service is counted.
You just look at the petition, WPCOC, which paragraph they say that they are getting pension. Look at page 6, para 6.3, page 4.
6.3 page, internal page 4 and 23 running page.
Look at annexure 4. Through copy of the pension payment order.
Pension payment order.
Annexure 4.
4. One judge.
No, what is wrong with this?
Miller.
Why is in the order of the learned single judge? Come to learned single judges order. What is wrong with this
What
order?
is that? Page 18.
180. No, you have quoted one order, no? Justice, Honorable Justice B.R. Sarang is
Miller, that is at page 18.
page 18.
Yes, ma'am.
This is one. The judge said, he has quoted what this court other coordinate benches have said. And coordinate benches have followed the inner voice of the apex court judgment. Where is the case for you in appeal?
That Nityananda Vishwal.
Huh?
That Nityananda Vishwal. My humble solution would be that it is quoted Miller at page 18 at the bottom.
There is that when reading the brief, we don't get anything from, we don't annex the order of the Vishwara.
No, Miller.
Under single judge,
On the letter and speech.
petition doesn't disclose that.
No.
You have to, at least you have to, in appeal, you have to enclose that should have been.
Nityananda was decided by the administrative judge. Matter came before the review was here. They would agree with the claim. Matter you took to the next apex court, negative legal case. When the case for appeal for you. Apex court decision which say what is meant by qualifying
But
service.
recently, my lord, my humble submission would be
What is not They do count their contract job period while computing the qualifying
qualifying service.
that is the question.
And the total period has not been reckoned.
They are not reckoned.
Yes, ma'am.
What is the reason?
May I submit 1 minute?
Yes.
In the recently, series of cases has been carried out to the Honorable Apex Court. In the month of end of March, actually, that judgment I will carry, my lord.
When?
Tomorrow, my lord. Recently in the Odisha case, my lord, and thereafter, my lord.
We are not getting the vendor on installment basis.
After tomorrow, my lord, after recess, after recess.
Send to us. This is a war of bits. This is a war of bits. In the war, the opportunity of hearing would not be given by the opponent party to you. Alright? It said you have to bring all your weapons. You can't ask him.
After lunch, I will come with the decision. After lunch,
This applies to you. We will not waste time.
I'm from the opposite party, Lord.
Let us. You will bring it day after tomorrow?
no, my lord, today also I can. Today also I can.
No, don't be in a hurry. Because your
Make some effort.
data and everything is all convoluted when you're making solution. Come day after tomorrow,
Yeah,
at least please bring those judgments.
judgments.
The Nitam Division dealt with qualifying service of the entire period of service. And whether it dealt with the pension rules.
Yes,
The difficulty would be somebody regularly recruited for no further thing, was for 20 years. He's a person.
He worked from 1978.
70.
And this person worked for, say, 40 years.
78 to 2012.
Well, 78, 88,
Around
2008, and so 34 years.
34 years.
So that this varies to the other. He worked in the regular establishment for 1 month.
Only 15 days.
15 days, less than 1 month. The person working for 20 years or 25 years will be getting less pension than me. Because you can't enlarge the qualifying period as per the pension rules who are Here's applied. Let's take the interest procedure. This person was worked for 34 years, 15 days in the establishment will get more pension. So if you apply the pension rules, it only says 10 years of
Qualifying service.
So you have added 9 years, 11 months.
9 years, 11 months, 15 days.
And getting pension. The second aspect, you please find out whether he's actually getting any benefit
Yes.
by counting.
Reckoning the period of
Because
contract.
as far as the pay scale is concerned, the pay scale is what he got. It could not have improved.
Yeah.
How do you calculate the wages in his 34 years of service plus pension? All these things can improve.
I'll go for enforcement.
There is a famous judgment of text on that. Just note down. T.S. Nakara
Yes,
versus Union of India. The other one is, of course, that judgment referred in that, where they have discussed how approach of the court and approach of the welfare government to the woes of the pensioners should be. All right? Just look into that. Justice Rama's services under the state. There is a famous book on service law. Famous books. One is Samaraditya Pal on service law. Another is Justice Rama Joyce on services under the state. Both they have discussed this aspect of the matter, referring to Justice D.A. Desai and the Lordship Denwa of the Gujarat Tribunal. Just look into both those books here. I got high discussion on this.
4, 5, 6. 4, 5.
Yes, brother. And whichever judgment we cite, you can note down and you can confront the judges. Sir, you had said this judgment, but it is not there. All right?
Yes,
This is a kind of challenge to the court also.
Not applicable.
Yes, not applicable. That way. All right? Books also will be quoting, so that we want to, you can upgrade yourself. We can upgrade ourselves together. All right?
problem.
All right.
Hi, my lord, same, madam.
Call along with.
This is day after 2 months.
Same along with.
And Mr. Mahanti, be sure that wherever you have not paid the pension, so please be sure so that our approach will be different.
That's fine. Because
Not my lord, and I also completely.
No, the Apex Court said that. The Apex Court said India is not an East India company. It's a welfare state. They interpreted several judgments in DS Nakara, and they discussed the idea of pension. Earlier, pension during laissez-faire era, pension was a bounty. Employer may give, employer may not give. Now it is not like that. Pension is defined under Article 317 of the Constitution, perhaps, as a consideration for past service. Therefore, because they will be in the evening of their lives. Evening is a bit difficult time for anybody.
Next part of
For you, for me, for anybody. Is it not? Evening will not be that pleasant, although sunset takes place. It will not be a pleasant thing. Many diseases, disablements, and later death also. Okay. Six. Yes, brother.
Mr. Sahoo, let him convince us. So you sit down. Wait for their performance.
Let us see.
Millard, may I pray that order dated 30/11/2024.
Page number?
Millard, this is the order number 1.
Order number 1.
Yes,
Can you tell the page?
Orders. Lordship's orders.
That similar matters are pending.
Before the Apex Court.
Exactly.
But how long they can wait?
That I will take instruction in the meantime further.
Earlier view was where similar matter is pending, ordinarily other courts in the tribunals should wait. Now that view we changed. That was the view in 1987. Thereafter, Justice Krishna Iyer's judgment, Justice Arijit Pasai's judgment from your state, they said, unless the Supreme Court interdicts, the court should go on deciding so that Supreme Court will have lot of material at their command, whichever we provide to them. Therefore, pendency, we cannot ask the citizen to wait. In the highest court matter is still pending. He will die away. Are you ready in the matter?
My lord, I have so far the instruction is concerned, I don't know. May I take the leave of this court to take the instruction of what is the status of that SL?
My lord,
He wants time. You are only respondent. We have not yet issued notice. Therefore, you need not be.
my lord, notice issued. In that question, the 917 days delay. Filing the writ of bill. And the similar matter is not pending with the Supreme Court.
It's not pending.
Not pending. My lord,
But they have mentioned that
my lord, in the year 2023, my lord, about 2,000 cases of various cases.
Take your response when he comes with that, because he himself saying he's not sure.
No,
So
no,
you allow him to that much of time.
My lord, I
to
will
respond. You make your submission on that day.
My lord,
You
just-
deny all his contentions.
Your
On the
lordship,
day when he.
your lordship, just 1 minute, your lordship may allow. In the
That's how court's time is precious.
We can hear you next time only. You reserve your judgment. We are not blocking that.
only I want to request your lordship's referral. 2023, about 2,000-3,000 cases writ appeals filed by the state in different cases.
Dismissed.
Whenever a writ has been disposed by a single judge, my lord, the state prepared the appeal. 2022-2033. My lord, in 2023, the Honorable Division Bench, the Honorable Acting Chief Justice, my lord, on the ground of limitation, varieties of cases, about 2,000 cases have been.
So all
the cases they have gone.
Can you please listen?
Do you have copy?
My lord,
Mr. Sahoo, can you please listen?
He has no copy of judgment.
The problem is that one of such decisions rejecting on grounds of delay has been recently set aside. Maybe to think of
In this case, man,
we cannot allow him to complete to listen. If you know what I'm saying, then you speak for me. I have no difficulty. The court eliminated dismissing petitions without considering merits have been the same now. In fact, one such judgment where for on the ground of 900 days delay, the High Court dismissed the WA, the Supreme Court has remanded it again. So please rule it for him. It is neither we are not deciding in his favor.
Yes,
Not allowing the.
it's because your lordship issued notice on the ground of limitation. That is why I am submitting.
Very good. We will have it
Definitely.
next day.
Who is condoning delay? How do you get the impression that we have condoned the delay?
Let us see. We'll have it, Mr. Sahoo. We have not formed any opinion. But within 3 days, heavens are not going to fall down. When do you want? 1 week? Next date we will not be giving again time. Okay?
I will not.
Yes. Call this matter next week at the request of learned GA. Finally. A sentence I think that's the matter. Yes. Yes, brother.
7, 8, and 9.
7, 8, and 9.
9 and 10 also.
10 also. Where is the order?
4 matters are my lord, it is at Annexer 2.
Page number?
Page number my lord, 34.
34. You have agreed that matter is covered. Brother,
Yes,
then how can you maintain an appeal?
no, for that, these 4 matters, I have to take a little bit of instruction because being agreed by this order, this intra-court appeal has been preferred in 4 matters. 7, 8, 9, 10.
That's all right. You have agreed to a particular fact situation, particular legal matrix. How can you maintain appeal?
It has been already been decided and put read WPC number such and such in view of the reasons.
Parties. No, that ground he has taken up. It depends upon the. What is the ground he have taken up? Supreme Court said in 1953, where parties make submission to the court that covered by the judgment. Ordinarily, no appeal on that.
But page 67 for a moment.
67.
Yes. At Annexer 8.
67.
The pertinent page is page 68.
This is delay condone?
Delay condone. And more particularly the petitions herein after pending special leave petitions preferred by the DD to dispose of the present special leave petition for by observing that whatever decisions that were taken in the pending special leave petitions preferred by the DD, parties shall be governed by this same.
What for you are citing this? This is not your decision.
No, it is not.
This is from Delhi.
So far the delay part is concerned.
No, question is not delay. Question is maintainability of appeal. You make an application before the learned single judge saying that this is not the correct position. Recall it. It falls under Order 47, Rule 1 and 3 of CPC. CPC is applicable to writ proceedings? Whether CPC is applicable to writ proceedings here?
Not strictly because that exception in 142.
No, but then in your rule,
But rule says the High Court rule says
High Court rules
independent. They don't refer to wherever these rules are obtained.
wherever they're required, they refer to.
Then you have to make an application before the judge. Appeal is not maintainable.
So, my lord, in 4 cases, I will take instruction because recent some developments are there.
What development?
My lord, so far these cases are pending, which has been disposed of. That I will take instruction, my lord.
No, this matter we are going now.
Of the case.
All right. The one which now you asked us to read, page 34, na?
34.
34 we have read. This matter does not survive. Because you told the learned single judge is covered by the judgment. Where is the fault in the judgment? To maintain an appeal, the consistent view of the Supreme Court is you have to show two things. One, order is wrong. Number two, order is wrong and unsustainable. Not just wrong. You have to show unsustainability. But how are you going to?
In your appeal, have you stated anything regarding that? What fell from my lord? In your appeal, grounds or wherever, have you stated anything that we did not say so?
We did not say so. Learned single judge wrote it wrongly. Even then you have to go before the learned single judge.
Not wrongly, it has not been.
Then you go before we'll reserve liberty to you. There is one judgment of the apex court in identical matters where a judge decides the matter on the ground that it is covered by a decision because such a submission was made to him. Then 6 of appeal memo.
Internal page 4.
Parasites you have taken up some attention that you never made such submission.
But Samson and that apart, the similarly situated matters have been disposed of, but they are all the way different because it is MSCP and RSCP matter.
So, that is the court has not gone into very
That's good. But like I said, when I asked him,
you have to respond to the
question. Para 6, internal page 4.
At para 6 of the appeal, it is averred by the state appellant as a first, in view of the above.
Delay?
Delay
Is there?
Delay is there, my lordship.
Issue emergent. Both on the field accompanying the same. But even in such matter, Supreme Court, there is a judgment of apex court saying that in that matter, you should move an application seeking recall of the order. Anyway, let us see what after your friend comes, we'll consider. I don't remember that judgment, but it's there in my notes.
7 to 10, my lord. Same department. 7 to 10.
Same.
Yes.
Same paragraph. Is it same paragraph?
Yes,
Para 6 only?
Yes,
in all matters?
Yes.
Then recall that. You write this way. Then I will recast that order.
I'll have to check.
Okay. Now, instead of saying that one, learned single judge had disposed of the matter by the impugned order, recording that both the sides agreed with a particular fact matrix and legal matrix as well in the light of settled decisions. First one, the appellant at para 6 of the appeal memo has taken up a contention which purports that there was no such agreement at the bar which the learned single judge mentions in his order. First off, thus a case is made out for issuance of notice both on appeal memo and on application accompanying the appeal memo. First off, issue emergent notice. Okay. Issue emergent notice accordingly.
11.
It's a government appeal against acquittal.
So,
Counsel.
And there is this case.
Just a second, let him know. Yes, come.
Yes.
Lordship, I am appearing on behalf of the respondent number 1 and 2, my lord, in BC matter.
Yes, brother.
Lordship, I am seeking for an adjournment, my lord.
You want adjournment?
Yes, my lord.
Which date? To which date?
7 days, my lord.
Which date you want? That you can pull down a date from the calendar.
Twenty-fourth, my lord.
24th.
Yes, my lord. 24th.
All right, government is okay. 24th. Okay. Call this matter on 24th as unanimously submitted at the bar.
Grateful, my lord.
We have noted that Shri Prabhas Pujari, learned counsel appearing for the respondents, has appeared online and had sought for a short accommodation. First of all, therefore, the above order. Yes.
Item 12.
Yes, sir.
Board of Secondary Education appeal against the after pass of the Honorable Single Judge in the next of
You also don't have a mic facility here. No mic here. Kindly be little louder.
I think we have this kind of famous.
That's why. Yes, sir.
I'm sorry.
Sir.
But Board of Secondary Education Orissa is the appellant against the judgment of Honorable Single Judge in Annexure 4.
Annexure 4, page number?
Page 42. 43. The respondent number 1 here is
He granted relief to the writ petitioner.
yes.
What was the relief petitioner had sought for?
The petitioner had appeared in HSC examination in the year 1990.
1990.
90.
HSC means
High school certificate.
high school certificate. Is it equivalent to 10th standard?
Yes. There his date of birth was recorded.
Date of birth was recorded there. Recorded as
26/5/1972.
yes, sir.
He made an application in the year 2022 that his date
For rectification
for rectification of his date of birth
as
26/5/75. 3 years wanted to add.
to whom he made that application?
He made the application to the Board of Secondary Education, which was rejected.
It was rejected. Whether the board has power to decide date of birth, disputes relating to dates of birth.
Yes, the question is, there is a regulation. There is a regulation.
Read that.
Regulation says that if there is a clerical mistake.
Clerical mistake. Therefore, I wanted to have the text of the regulation.
Yes.
Clerical mistake is one thing. Dispute is another.
Yes. Date of birth, just I will place it. The date of birth once entered in the board records cannot be changed unless it is of the nature of a clerical error or printing mistake. Application for the correction of the date of birth should be made within 3 years of passing the examination.
Oh, even then, even if it is admitted to be clerical error,
Then it's
there is a limitation for that.
3 years.
How the judge has considered this aspect of the matter?
Let me just complete one more
Very
line in this provision.
Very well.
No change in the date of birth recorded shall be made unless the application for correction is received through the head of the institution concerned within 3 years of passing the examination.
So modality is also prescribed.
Because obviously,
So 3 things you are arguing. Number 1, it cannot be said to be clerical error at all.
yes,
Number 2, it is beyond the period of limitation. Number 3, the modality has not been followed. It has to be routed through the head of the institution.
obviously because the school records
Because it will have many consequences.
Right. So here what has happened? He made a representation And
On which date?
his representation was rejected
On which date he made the
in
representation?
2021.
21. Requires
24/11/21.
Will issue notice and any interim order you have sought for?
I said stay off.
Whether there is a delay?
No.
No delay? Requires consent. Covered by the judgment of apex court. But the learned senior advocate, Shri so appearing for the appellant, submits that the date of birth entered in the HSC certificate is final by virtue of regulation 39 of
Those regulations.
so and so. See that and write down so and so. And only a certain kind of rectifications are allowed, and that is subject to a limitation of 3 years. First time. He also submits that changing the date of birth in the school records will have far-reaching consequences, and they may affect rights of others too, like retirement, etc. First up, we agree with this view presently. First, issue emergent notice to the respondent and interim order as prayed for in the accompanying application, supported by the affidavit.
File reproduction within 3 days.
Pardon, sir?
As in file reproduction within 3 days.
Signature.
What is that? Filing of insurance of notice, posted the periods.
I think rule will say that. So, it's a rule position. If they want to file, they can. Otherwise, they may not file at all. We can't ask the defendant to file the WS. If he wants, he will file one. If he does not want, we cannot compel. Yes. There are 2 judgments of Supreme Court on that. Kindly bring that. Yes. 1-3. Yes, Mr. Das.
1078 of 2024 at flag 3 for condonation of delay, seeking condonation of
delay. On merits, what is say something on merits? Let us see.
Akin to my learned friend with the arguing item 4 that Nityananda Biswal case was.
Which date we have posted it to?
Day after.
Day after. We'll call this matter day after only.
Yes. Day after.
Yes. Call this matter a day after. Below WP number so and so. That other matter, na? Below that it should be posted. Yes. What is this matter about? Disciplinary inquiry.
Yes,
what happened? What was the misconduct?
Regularization of service, madam.
Regularization of service.
DLR NMR.
Means?
So daily liberated nominal booster road.
In your state, that is the nomenclature.
And they are using this charter for person. They should mention the full state.
Of course, because we will not be doing that.
Yes.
Now, what is the fault with this judgment, brother?
Single judge has held that even if the appointments are irregular, still then direction has been given to regularize.
The question of regularization arises only when appointments are irregular.
Yes.
If they are illegal, no. Umadevi says, Umadevi says, illegal appointments cannot be regularized. Irregular, they can be. What's the case? Then where is the fault with the judgment? All right, now we are asking you, how to decide an appointment is illegal or an appointment is not illegal but irregular? What are the parameters?
When it is directly against the statutory provisions and beyond the statute, that is illegal, per se illegal.
Correct.
And when irregular means that he could have been entered to service, but by backdoors or some concession has been given, and services have been extracted for a considerable period of time.
How many years he has put in service here?
The record shows that 27 years.
Then you can't reopen what happened when Babur had come here in 1526. At least that irregularity, these things, you should not have allowed him to work for 26 years. 26 years in a man's life is a very long period. You can't be that cruel. State cannot be cruel. State is a model state.
Is 22, para 4 of the judgment that reflects that they have completed 27 years of service in the meantime, and even though their appointment is irregular, they should be regularized in service in view of the judgment happens. That woman they did that.
Issue. Issue notice reasonable within the things. We'll make it 50 rules. That's the only point. You did not argue. The subject single judge has not said whether it is illegal appointment or irregular appointment. That's the only point.
Yes.
That you should have said.
Vice President question.
Delay is there.
Delay is there. No, delay is not there, bro. Delay is not there. No, not there. Not there. Only dispensing certificate. Certified.
Stated in the affidavit, in supposed affiliation, dispensation has sought what is said for. Yes.
Item 15, my lord, in the merit of the case is that after retirement, disciplinary proceeding whether can be initiated or not.
After retirement.
After retirement.
How many years?
That is the crux of the matter.
No, on which year, in which date year you retired and which year you initiated the proceeding?
What is the rule prescribes?
Rule 7 of the OCS pension rules, bro. Rule 7 of the OCS pension.
No, first you give the dates, not say past.
Please tell when he retired.
You sit down, Mr. Ratha.
Have you permitted to give the dates?
No, you don't be exuberant. Let him.
We will come to you also. We will not pass any order against you without hearing. Yes. When did he demit the office? All right, Ratha.
31/3/2020, my lord.
31/3/2020.
2020. Proceeding was initiated on 36/2020. 306/2020.
What is meant by initiation of proceeding? How proceedings are initiated? Supreme Court says a disciplinary proceeding is initiated when the charge memo is served on the delinquent employee. A criminal proceeding is initiated when the FIR is lodged against him and cognizance thereof is taken by the magistrate. So when did you issue the notice on him? Mr. Rath or Ratho? What is that? Rath. Okay. Is it Jagannath Rath? That way? No, not like
that. Surname is option. Well, here, the only grievance is...
All right, we have understood. Both we come from service law background also. Therefore, answer you, what was the charge?
The charge was for disproportionate assets, my lord. Acquiring of disproportionate asset.
What is the extent? Percentage?
My lord, that is the tune of 51 lakh.
No, percentage.
Known sources of income. What excess he had?
My lord, as per the statement of imputation, my lord, That is at, my lord, may kindly see page number 25.
We are asking a question. How many teeth? You need not open the mouth at all. You can just quote the number.
My lord, here the percentage has not been, my lord, mentioned.
Not mentioned.
Because, my lord, in the vigilance case on which it was initiated, my lord, charge sheet has not been filed. Here, my lord, what the rule says, my lord, rule 7, it says that the charge memo in department has to be served on the date of retirement, before the date of retirement, or charge sheet in a vigilance case has to be filed and cognizance so to will be taken, my lord. Here, my lord, the dates are very vital. If my lord may permit, I'll submit.
Yeah. You said 31/3 is debiting of office.
My lord.
30th June is date of service.
Date of service on the date of departmental proceeding, initiation of department proceeding.
Correct.
That is not his book. But my lord, vigilance case registration.
No. We are asking regarding DP, you are going on vigilance case.
This is the disciplinary inquiry.
Departmental proceeding we are discussing, so please don't veer off to vigilance proceeding.
I am sticking to the single judge
don't.
judgment, my lord. That was the discussion.
Mr. Rat, the facts we are discussing, it is for single judge, division bench, Supreme Court, same. So why you are,
Yes, sir, brother. How can we
mentioning the date and all these things?
Date, my lord.
Which rule applies?
Rule 7 of the Orissa Civil Service OCS Pension.
Be specific, Mr. Panda, 7(2)(b). Straight away come there.
Yes, 7(2)(b). Such departmental proceeding as referred in sub-rule 1.
Just, you are running ahead now.
No.
Page 37.
Yes, sir.
Such department proceedings as referred to in sub-rule 1, if not instituted while the government servant was in service, whether before his retirement or during his re-employment, shall not be instituted, save with the sanction of the government, shall not be in respect of any event placed more than 4 years before such institution, shall be conducted first by such other disability. 4 years within
the occurrence should be prior to police. That's one limitation. And institution, there is another limitation, sir.
That is interpreted by the Apex Court in 1988 under Karnataka Rule 214 capital A of Karnataka Civil Service Rules. If it is 4 years prior to the retirement, then it is open to them.
My lord, in any case, I am not challenging that DP method. Here, my lord, I am praying for my pension and pensionary benefit that ought to have been released just after the date of retirement. Because on the date of retirement, undisputedly, I had a vigilance case registered against me. No charge sheet was filed. And the DP was initiated 3 months after my retirement date.
No, Mr. Roth, you are not referring to the rule. If you are entitled, then he has mentioned Rule 7.
But I am reading that.
So
explanation.
You have got your provisional pension?
My lord.
So whoever is retiring, maybe with a DP pending, vigilance case pending, or he gets, suppose you have a clean slate, you will get final pension or the provisional pension.
My lord, here on the
no, please answer. Don't go on in circles. That doesn't help. So you straight away say, suppose a person, you are decorated. You are decorated, you are well decorated, you are awarded, you retire. You will get on the first day you will get provisional pension or final pension.
On the first day of provisional pension, but the pension will be transferred, my lord.
So please don't go on a speech of that. Please, it's not. It doesn't help the discussion. It's a serious courtroom deliberation. We are going state by state.
Brother, what Apex Court says is, if it is an incident which happened less than 4 years before the retirement,
the issue notice will be quite speedy. My lord, please, for a moment, I may be given a chance to quote Rule 7(2)(d) and its explanation for a moment. Yes, ma'am. 7(2)(d).
It's your duty to look at the rule and give us
Not giving the book.
My lord, I be permitted to read, my lord.
Rule 7.
Rule 7, 2, clause D. Clause D.
D.
My lord.
Case form.
In a case of government servant who has retired on attaining the age of superannuation or otherwise, and
Was retired when
my lord, Rule 7.2D. I was.
yes.
My lord,
Yes.
in the cases of government servant who has retired on attaining the age of superannuation or otherwise, and against whom any departmental or judicial proceeding are instituted, or where departmental proceedings are continued under clause A and B, a provisional pension as provided in Rule 66 shall be sanctioned. My lord, then explanation, my lord. Explanation.
Where is the government?
For the purpose of the rule. Departmental proceedings shall be deemed to be instituted on the date on which the statement of charges are issued to the government servant or pensioner, or if the government servant has been placed under suspension from the date of suspension, then judicial proceedings shall be deemed to be instituted in case.
That will not apply. This is not a judicial proceeding.
My lord, here the single judge bench has dealt the judicial proceeding, my lord.
This is a D.
No, my lord, it's a criminal proceeding, my lord. Yes, my lord. My lord, kindly see the influence.
We are not as fast as you are. We wish to be as fast as you are. Perhaps faster also. But just to show that what was challenged by your mind was criminal proceeding.
My lord, I was praying for in the read petition, my lord.
Not the.
My lord, in the read petition, I was praying for release of the pension and pensionary benefits. The prayer was simple, my lord.
Challenge was challenge.
I did not challenge my the vigilance case of the DP. I did not challenge it. My lord, here, what I am
asking for them or
no, my lord, I am submitting. What
it would have been better, it should have kept quiet.
No, my lord. What I am submitting, my duty is to submit, my lord. What I am submitting.
Absolutely. Absolutely. It's a great pleasure to hear you, and as fast as you are submitting, still my better pleasure. But did you challenge the D in your?
They have not challenged.
My lord,
you sought for release of the.
I am not prejudiced for with the DP, my lord.
That's not
because no, my lord.
We hear our argument. Sometimes that is also I think. Is it not? No. Why is said that? In every in Kannada also. Already we have such a if the incident has happened 4 years prior to retire, then the proceedings cannot be instituted. If it has happened within that particular thing, proceedings can be instituted. The rule which you are referring does not refer to these proceedings. It only says when these proceedings are deemed to have been instituted. They say they are deemed to have been instituted. Where charge memo is served in the case of D, where the cognizance of a complaint is taken by the court in the case of a criminal proceeding. Same incident can give rise to a disciplinary proceeding and a criminal proceeding also. Maybe tortious, maybe contractual also, we don't know. Now, you did not challenge the DA at all. You had sought for release of the pension. Is it not?
Yes, ma'am.
The court permitted you to take the pension,
Yes.
provisional pension.
No, sanction the final pension.
Final pension.
Because, my lord, on the date of retirement, whether a proceeding was...
There was no proceeding pending.
Yes, my lord. And on the next date itself, I am eligible for my gratuity, my final pension and other retirement benefit. The learned single judge bench has also referred to a division bench of this honorable court, which was subsequently, my lord, I have, in another 14 bench, the refer it has been implemented.
See, whether institute proceedings or not. Depends on the aspects.
Yes.
I comment.
Yes, I'll do that.
Okay. I will also look at this.
Look at rule 66. 66. Can you look at this? Yes, sir.
Manual.
Challenge the receipt of your provisional pension in any proceeding.
No.
You have challenged your receipt of provisional pension after the TE and the criminal case.
I have challenged, yes, my lord. After the criminal case, the registration of criminal case, and after the yes. Only the thing is whether what is the definition of ending at the time of retirement.
No, the way you are interpreting would be correct also, Mr.
My and there is a delay that has been.
Then according to you, you have to answer also. Then in which case it can be stopped at all.
Yes,
If we go by your version,
yes, ma'am.
in no case it can be heard.
It can never be.
My lord, it can be heard.
7 and 66. 7 and 66 now you have read. That would be rendered it also.
What use? What use?
Yes, ma'am. Much obliged.
What is the delay actually?
But provisional pension, you are sure you are getting?
Yes.
With all everything.
That you will not want. Because we have to hold body and soul together.
No. Provision pension will get.
How many days delay?
But that we have not 230.
237.
Depend on the
My lord, my condon, my lord, decided on merit.
You give one good book to the library. Which book you will? You learning the law by glad Williams to the advocate.
No, we'll provide that services under
Services under the state
by Justice Raman.
That's in that
Clarification.
Appeals filed on booking it in of 237
days, my lord, as coming.
First, an application is moved, supported by an affidavit. First, Learned counsel appearing for the pensioner opposes the application, saying that delay is too long and declaration offered is not possible. First, next, having heard of the counsel for the party, we find that there is an arguable case on merits of the matter, and that delay is not too long to be disarmed. First of all, adjudication of delay would not add merits to the case of the appellant, and that no prejudice should be caused to the other side if delay is continued. First, we are aware of the fact that more older cases than this are still languishing in the cupboards of the court. First, therefore, we can't assume that had the appeal been filed in time, it would have been heard and disposed of by this time. First, next time, in the above circumstances, publication is favored and delay is condoned, subject to the condition that the appellant shall present a set of 2 books, namely services under the state by Justice Raman Joyce to the Advocates Association Library. Within what period?
We have to purchase it from Amazon, my lord, because or we will search for it.
Within 4 books. If books are not presented accordingly, the publication.
Yes, 4 weeks. 4 weeks. 4 weeks will not do.
Much obliged.
Lordship, next day.
Next day. Come after post complaint 4 weeks.
4 weeks. Yes, ma'am. 8 page Lordship notified. Order dated 28/11/2022. Lordship called for the relevant file in which the final order dated 36/2017 is there passed and communicated to the petitioner. I have obtained the file as per Lordship.
But you have to prepare the index and assist us. You can produce
My lord, only short question is whether the order is supported by any reasons or not?
No, why the court directed for production of that record from the bench?
Because Annexure 9 doesn't contain any reason that they have challenged.
Yes, Mr. Author, that's the case.
There are multiple facts here.
No, anyway, which is the impugned order?
The Lordship is page 15.
By 9.
Right. Apparently, the impugned order doesn't show any reasons. And also, they said there is no application of mine while rejecting the passing an order that debarring me from getting the employment.
Debarring you from getting employment.
But
Is it a disciplinary proceeding?
No.
Huh?
In fact, the petitioner is a lower judiciary employee. He is a clerk now present serving in the judgeship of Kerala. He is a scheduled caste person. He, as a direct candidate, applied pursuant to the advertisement for being for facing selection process in the year 2016. Now, he appeared in the same, his admit card was issued. He faced selection process. He passed out in written test, passed out in viva voce test. He was recommended to be appointed. Thereafter, a so-called notice was issued saying that you have not submitted the NOC from the employer or your application is not processed through the employer. That is why you are debarred from getting it. I gave a written reply.
How many years you were in employment?
The present employment or as a clerk or but he has been debarred. He has not been issued with appointment.
He has not been issued appointment order. So on the ground that you did not get the NOC from your previous employer, is it true or not true?
Beg pardon, it is true.
You did not get.
I did not get. The reason being that I explained it in my reply. My detailed reply is given.
Saying?
I say that there are three categories of applicants. One is a direct, other is a judiciary, a person serving in lower judiciary or subordinate judiciary. Third is a government employment. Now, if I apply for the Vijay Kumar Misra's case, he referred to the 2016 Supreme Court, but he referred to saying that merely because I am an employee, I am not debarred, I am not disqualified from applying. As a direct candidate, if I apply, I don't require any. If I apply as an in-service candidate or a departmental candidate availing relaxation, then I am required to enroll.
Where is the rule? Well, let us see the text of the prescription. Which rule says?
Right.
That it depends upon the text.
The rules governing the pleading. But I'll take your lordship.
No, now only. What the rule says.
Right. Lordship sees.
Referring to which rule?
This is OSJ Rules 2007. Lordship will get it in the book, volume 10. Or
Local Act, volume 10.
Local.
Local Act, volume 10, page number?
This is in my book, it is page 281.
Local Act index
Which rule? Which rule? You listen to
Odisha Superior Judicial Service and Odisha Judicial Service Rules 2007.
What the lawyer is saying, that rule you have to show to us. That's your duty. We will not turn the pages. Yes, sir. Which rule?
Lordship sees rule 18.
18, 1-8.
Right, 18 and 19.
Eligibility of candidate for the post of civil judge.
Right.
Which is the sub rule?
Your Lordship will find it sub rule 2B.
2B.
Right.
Has been recommended.
Right.
By the respective appointing authority
and not more than 39 years of age, first day of 18th August of the year in which the applications are invited. Lordship got it.
Yeah.
Right. Next also your Lordship will see rule 19.
Every candidate shall submit the application in handwriting.
Provided that a person already in government service, applications shall be submitted through appointing authority. That's the
Correct.
These are the two qualifications are there. I mean, the requisites are there in the prescriptions are there. But fact remains that the petitioner is saying that I am applying as a direct candidate, not as a departmental candidate. In the application also he has clarified.
No. It does not differ. See the text of the proviso. Proviso is as clear as Gangetic waters. It says every candidate, he uses the word every, any, which Macaulay used in IPC. Every candidate shall provided that in the case of a person already in government service, the application shall be submitted through the appointing authority.
Right. But
You may be a direct candidate, whichever candidate. It does not, proviso does not recognize that factor.
Right, if Lordship will see that Vijay Mishra's case, the situation was also like that.
Interpreted.
Lordship may
This provision is interpreted.
I'm not. Yes, I think I can convince your Lordship about that. No,
Sure,
besides this, no, this is a. There are also two more adverse points against me, which I have to meet with.
No, first one is you did not forward your application through your employer.
Through the employer. That's there. That's there. But I have my today my limited point is, Lord, if your Lordship will appreciate this, your Lordship see the impugned order. I have given a detailed show cause. I have explained that in my reply. Lord, in the impugned order, they have absolutely not assigned any reasons.
That's all. Your reply should convince us now.
Right.
Rule says, proviso says,
Right.
you have to route your application for appointment, recruitment through the employer.
But kindly see my reply.
What is the reply?
He says, but he has tried to explain it in his reply.
What is that? It does not admit any reply at all. But the text of the proviso is
But
very,
he
very
says-
clear.
No, he is not required to give take. Kindly see that reply that is at page.
Show that. How this rule is interpreted by your High Court?
Not our High Court.
Any High Court?
I'll cite one Supreme Court judgment in that regard.
Give that.
So, Vijay
Mr. Lordship is having.
Sir, having that.
Yes. 2016 3.
16.
Yes. What does it say?
Which paragraph?
Paragraph 24.
Now, so now check it. 24 you are saying. 24.
Yes. No, it's a case of a district judge.
Any person, it covers everybody.
In my opinion, there is no bar for a person to apply for the post of district judge if he otherwise satisfy the qualification prescribed for the post of engineering in service of the union or state. It is only at the point of appointment the question of his eligibility arises. Denying such person to apply for participating in the selection process when he otherwise fulfills all the conditions prescribed in the advertising reports, clause 2 of Article 233, would, in my opinion, amount to violating the rights guaranteed under Articles 14 and 16 of the Constitution. If your Lordship sees in the rules, in as much as the advertisement, there is no such disqualification that if a person is an employee in the subordinate judiciary or in government service, he is debarred from applying. He is not qualified to apply.
Now, what was the rule there, which Apex Court was interpreting?
But here,
There was a case where
there was a case where he was continuing in the lower judiciary. And
So, thank
without
you, sir.
resigning,
Which is the rule they considered? Your court, your state rule only. This is a case arising from which state?
That this is this 16,
Ah,
I think from Bihar.
Bihar. What was the rule position there?
But the position here is a person who is in service cannot apply unless he resigns from the post. He cannot be appointed. I'm so sorry.
Yes, sir, that's not the point.
That's the point. That's the point.
That's not the point.
That is the decision.
That makes no sense to you.
But here,
Rule says, unless you challenge the rule says, if you want employment, you have to route your application for recruitment through your employer. Have you done it?
the rule is challenged here also.
The rule is also challenged.
Yes.
On what ground?
I'm not saying that this debars me, this affects rules is also challenged.
But this rule has been there since very long.
Yes.
And such rule is there in many states.
Yes, and then rules, of course, if rules is under challenge, maybe I think the roster will go somewhere else.
Is it?
Yes.
Rule challenge do not come to us at all.
No. Sorry, Lordship dealing with the assignment.
So then
if hires comes,
then it can come.
Assignment, hires candidate.
Previously, no, they are not.
Only challenge before us only.
Your Lordship can. I'm sorry, your Lordship can.
First, the learned single judge, how reasoned out?
Beg pardon?
Single judge reasoned
No,
out.
it's
How?
a direct petition.
Direct petition
Direct
because of employee.
Yes.
We don't agree that rule is bad. There is a presumption right from the days of Ramakrishna Dalmia versus Justice Tendulkar, that every statute and statutory instrument are constitutional. One who attacks has to make out a very strong case.
That's it.
That case you are not making.
That I'll have to make out. Maybe I'll have to come with those judgments before your Lordship.
No, the time will not be given.
Then it has to be decided either.
But we are not going.
Because otherwise I can't have a better point, because the position as it stands today, he has not taken any ownership from the employer.
They have not taken. That's the point.
No.
The other point is?
But other point, if you see, they have said that though it's not there, with regard to that.
Why you debar him for that? You can say that we will not grant you employment. How can you debar him from employment elsewhere also? How is it done? How the order is done? Take us to the impugned order.
Page 15.
50.
Yes, but page 59.
59.
Kindly see this order. But
9.
correct.
No English.
Annexure 9.
File 9 is an annexure containing the
Order dated 30th of June 2017.
You are 14410 of 2017.
14410 of 2017.
Sorry. So this code through again. High space bar.
Annexure 9, if you Lordship,
This is the order. Can you face the order?
After careful consideration of the so-called reply submitted by Dibakar Patra, son of so-and-so, in response to your so-called notice dated so-and-so, the government have been pleased to debar him from employment under the government.
Where is the power to debar, brother?
Rule 21 of that.
Rule 21. Power to debar is a very serious matter. Misconduct in the examination. Where is the misconduct in the examination?
Concealment of fact, that aspect.
What is the concealment?
You have the rules. So conduct.
No, I am not.
Read it. A candidate who has been declared guilty of impersonation or submitting fabricated document or document specified.
Such a thing is not there.
Now, where is that? How can you debar it from that? You not punish him that way. You can say that you will not employ him.
Yes.
Only the fraud, fabrication or duplication, impersonation.
At best, it can be making statements which are incorrect.
That's all. Debarring may not.
May not be a proper phrase.
That may not. That is not provided there. Right to consideration of public employment is recognized as a fundamental right under Article 16. That you cannot.
One more data.
One second. Let us complete this aspect. Are you agreeable? You have read the rule now. Does it enable you to debar in that
It is explained in the order. May I read the entire order?
Which order you are referring? Which page?
The file. When the thing
The file may not, because if it doesn't contain in the final order, impugned order doesn't contain any reason.
That
File it contains the reason, my lord.
in Mohindra Singh Gill versus Chief Election Commissioner, AR 78 Supreme Court, page 851.
correct.
The apex court said, you cannot sustain an order on the grounds that are not in the order
Yes,
itself.
public orders passed publicly has to be decided on the basis of the reasons are
They
said.
should be pregnant with the reasons.
In
You cannot
95
bring
Supreme Court, my
pseudo-
lord, I have a decision. In 95 Supreme Court, Honorable Supreme Court said that if the order doesn't contain a reason and if the file contains a reason from which the order has emanated, then also it will suffice. 95 Supreme Court.
Read.
What do you mean by emanated?
But
I mean, the order has referred to that
But
particular
that
aspect.
refer to that.
other hand,
You can't supplement.
In that case, I have two answers. If the Lordship is the LIC of
Oh, he-
I'm
he's
so sorry.
articulating.
I'm so sorry.
My lord, that is the decision in the 95 Supreme Court. The SS
Vendor single and the prior decision. I think it is.
Minor 78. Now it is 90.
Govardhan Das.
Supreme Court case.
Govardhan Das.
Govardhan Das Banje versus State of Bombay, something like
Right,
that.
State of the
Both still
State
hold
of
the
Maharashtra.
95 has not
Govardhan Das, Constitution bench.
52 Supreme Court.
But yes, you are right. If you have referred to that particular aspect
Yes.
in your order, in the file, in the from
For
section,
that reason, or also for the file.
no, you have to be convinced to show us.
No, not like that. Now, AR 1952 Supreme Court, page 16. Take up. Govardhan Das Banje versus Commissioner of Police, Greater Bombay.
Yes, sir.
That say a public order,
Public limit.
if it is challenged, its sustainability has to be accomplished from the reasons stated in the order itself.
Cannot be subsequently explained.
Explain. That is reiterated in Mohinder Singh Gill versus Chief Election Commissioner, AR 1978, Supreme Court, page 851. That's it. These two decisions are to an extent referred to in 1995. Provided, as my brother pointed out, you should be in a position to take the judges to the file by reference, not by a roving inquiry.
No, by reference. No.
Reference. Where the order refers? Where have you stated? That we have stated the reasons in the file.
No, that I have not said.
That ruling is not applicable.
I exhaustively contact the reasons, my lord. We have exhaustively discussed.
Question is then,
We can't insert that. There can be two views. See, when you do not refer, can you say that yes, perhaps you referred?
your reasons will be in your go down.
You have to be very specific to stand.
You can't do that. Your reasons may be in your go down.
Yeah.
Do you admit, allow the citizen to enter the go down?
No.
No. Citizen should know. It's a good governance constitution. Our constitution is a good governance constitution.
In fact, it's no point.
You can't say it's not a colonial rule that will not give reason to it. You have to give.
My lord, may I read that para 95 Supreme Court?
Read.
It is also settled law that the order need not contain detailed reasons like a court order. Administrative order itself may not contain reasons, or the file may disclose reasons to arrive at the decision showing application of mind to the facts in issue. It would be discernible from the reasons stated in the order.
There should be, your file should be linkable to the reasons stated in the order itself.
Or the contemporaneous record.
Contemporaneous record means at the same time those which have been produced. That is explained in 2002 Supreme Court. You are reading 95. It is explained in 2002. I don't remember.
Reasons are the link between the order and the mind of its maker.
That's the reason why reasons have to be disclosed.
2008. This is presented.
2002 Supreme Court.
The reason is the living link between the mind and the order.
That is there. That English.
Lord LIC of India, Lordship will see LIC of India, that's saying, what is the meaning of the word consideration?
LIC is 86 Supreme Court.
LIC of India 2006, 2013, I'm sorry, 2013.
2013.
The word consider is explained. We'll have to
No, anyway, we are asking you, how can you debar a citizen from going for employment market?
If that is not in the statute itself, we certainly cannot debar. If the statute contains debarring that concealment, etc. On this matter, they apply.
Nothing like that. We don't do. This is not an installment basis. We have told the learned senior advocate. It is being told to everybody. We will not do things on installment
For the
basis.
research, only one adjournment.
No. Question is not that we would have given you, but we have waste the public time that way. Whoever, whether senior advocate or junior advocate, come with full preparation, snatch the order from our hands. No different treatment for senior advocate, junior. Only performance, not performance. Only two classes. That rule we do not agree that it is unconstitutional. Writ petition is allowed on the following grounds. Kindly be seated. Number one, partly allowed in the following grounds. The challenge to Rule 21 of OSJS Rules 2007 is repealed in as much as that rule enacts the state policy on the basis of the wisdom gained through the experience of governance. First off, in matters of policy, a writ court cannot run a race of opinions with the executive. First off, ours being a constitution, and one of the basic features thereof being the doctrine of separation of powers, the judicial institution has to respect the policy decisions of the other coordinate organs of the state. First off, there is a strong presumption as to the validity of statutory instruments. Wide R.K. Dalmia versus Justice Tendulkar, write down the judgment. Right. A strong case has to be made for rebutting such a presumption. First off, despite vociferous submissions, such a case is not made out before us. First off, therefore, the issue of validity of the subject rule is answered against the petitioner. Next paragraph. The above being said, the impugned order dated 30 June 2017, a copy whereof avails at Annexure 9, is reproduced for ease of reference. You have to reproduce them. Okay. The next paragraph. By text and context, it debars the petitioner citizen from gaining entry to the employment market. And this cannot be then done that easily by the welfare state in view of right to stake a claim for employment, more particularly public employment, is a facet of Article 16 of the Constitution of India, while Uma Devi versus State of Karnataka. First off, even otherwise, the text of Rule 21 does not permit building a China wall between an employee and the prospective employer. First off, the substratum for invoking the penalty clause enacted in Rule 21 is not demonstrated by the learned additional government advocate despite vociferous submissions. First off, we are of the considered view that there is no case nearby the precincts of Rule 21. Next point. The vehement submission of learned government advocate that the impugned order can be sustained by looking to the regions contained in the file does not much impress us. First off, law in this regard has been settled more than half a century ago in Govardhana Das Bhanje versus Commissioner of Police, Greater Bombay, etc., etc. AR 1952, Supreme Court, page 16. First off, the same has been reiterated in Chief Election Commissioner Mohinder Singh Gill versus Chief Election Commissioner, AR 1978, Supreme Court, 850, 851 or 850. First off, the public orders are not like the wine that would become better as the time passes. Come on, said Justice Krishna Iyer in the said decision. First off, a public order of the kind has to be sustained only on the regions contained in its own, and it cannot be, and that the regions cannot be supplied from outside. First off, the heavy reliance placed by learned AGA on 1995. What is that?
1995, volume 6 SCC 289, para 32.
Slowly, he has to write down.
My lord, 1995.
1995,
volume 6 SCC
6 SCC
289, para 32.
More particularly, para 32, that even an order bereft of regions can be sustained if reference can be made to the region contained in the file or contemporaneous records. First off, the text of the impugned order does not indicate that the regions are contained in the file. First off, regions cannot be stacked in a godown in the public offices. First off, that is not the case of rule of law. First off, in the above circumstances, petition is allowed in part, semicolon. The impugned order only to the extent that it debars the petitioner from staking a claim for public employment that is under the government is settled not. Rest of the things remain intact. So this is the draft of the order. That line, it will go. Little linguistic changes may happen. We have one request. Wherever you are ready, we will not give installments.
I know.
Wherever you are ready, you argue. Get good orders from us. When you are arguing, you can't say, we'll bring judgment tomorrow. We will not listen to that argument. We will not listen to that argument. More particularly from the senior advocates. We will not entertain such arguments at all. We are not here to launder the time, public time. Yes, the cost medicine.
Item 20, tomorrow I pray for 7 days time.
You want time? Yes, sir. When do you want, sir?
7 days time next week.
May.
26.
May interpret the application
1 week he wants, sir.
for intervention.
Intervention. You want to become a party here?
Yes, ma'am.
Intervener or as a party?
We want to become a party.
Party.
Yes, ma'am. The reason is we in terms of clause 4 of this advertisement, we have cleared the preliminary examination, mains examination, and we have also cleared the document verification stage. And subsequently, the writ applicants have availed an interlocutory order through which our appointment has been embargoed.
Then he will be a necessary party. He will be a necessary party in the light of Rajia Begum versus Shahnaz Begum.
Yes.
Will implead an application is moved by the candidates who have traveled halfway through in the recruitment process. First off, learned counsel appearing for the applicant points out that if the relief claimed in the petition is granted, his clients would be put to prejudice. First off, thus he is the applicant. How many?
Five numbers.
The applicants answer the description of proper party, if not necessary party, in the light of decision of the apex court in Rajia Begum versus Shahnaz Begum, AR 1958, Supreme Court, page number so and so. You have to tell the page number. Take out from your mobile and give that.
Let's add another judgment.
We have said that. We have said that in the basic judgment. Give that page.
Another IA for the same relief, standing on the same pedestal.
Kindly, in a piece of paper, you write the IA number and the name.
IA number 18.
No, we write it so that they can type it correctly.
Orders on IA numbers, signs, common order. Give that judgment. If he gives the page number, you allow the application. Otherwise, application rejected. Call this matter, petitioner to amend the cost title. Yes, sir.
I am appearing on behalf of the Position Staff Selection Commission, the recruiting agents. This writ has been amended and consolidated writ has been, wherein a rule has been challenged. The rule making authority, in this case, issuing authority, J&PG department. In fact,
And not made parties.
yes, not so, if he is taking the adjournment, at least that defect may be cured, so that it will not be further adjourned.
We can direct the implement itself. It's a writ petition. Writ petition, na?
Yes.
It's a writ petition. We will direct him to implement that so that again time will not be wasted.
Yes.
Another one, you can direct in the writ petition.
The writ so and so. Learned counsel, Shri so and so, panel counsel.
Yes.
Panel counsel points out that which party should, who is the
J&PG department.
The G&PG department, which is the truly answering respondent, ought to have been arrayed as a party opposing the petition. First up, learned counsel appearing for the petitioner fairly agrees with this proposition. First up, no formal application need be filed, since that lacuna can be overcome by making a direction to the petitioner to array the said department as a respondent number. Which respondent?
In his application, there are four.
In application,
Will be five. And the rest of applicants, they will be 6, 7, etc. That way you have to structure the order. You will structure the order. Issue notice to the newly arrayed respondent, Shri so and so, AGA, Shri Ponda. What is that? Yes. Learned AGA on request accepts notice for the said respondent. Petitioner to amend the cost title and serve amended copy of the petition along with all the documents on all the arrayed respondents.
Yes, sir, my name may be reflected. Union of India is.
You appear for Union of India. Shri so and so appears. Appears. CGC, learned CGC.
Right from name.
Right in a name.
In my IA application, there are 10 persons who are selected candidates who are sought to be included in this case.
Do you have
Accordingly, it will be my opposite party's numbers.
After 5, you request Mr. Malik to file the amended cost title accordingly because it is his responsibility.
Petitioner. Cost title is in the domain of the petitioner.
Yes,
Dominantly it is.
Provide the names.
All these things are
there in the application.
Yes, already.
Copy the.
Copy. I have.
Give one more copy.
I will give one more copy.
Copy and coffee. Whenever asked should not be denied. Give that. Yes.
How many applicants in your application?
6.
6. So 16 have to be added, Mr. Malik. Yes. Apart from 5.
You file amended cost title.
Okay.
2 weeks?
Yes.
2 weeks. Call after 2 weeks for compliance.
State appeal bills. State appeal. Lots in order is Annex 1. 11% is 19. Page 19. And the admission test, case has been disclosed, stating that his case is covered such and such.
Is covered by judgment.
Yes.
Is covered or not covered?
It is also since third paragraph. It is also stated that it is agreed by the law and counsel for the party that issue involved in this case is analogous to the involving petition number.
Same. Well, para 6, they had taken up certain contention in those appeals. Do you have para 6 like that?
No.
You don't have.
That is the ground G.
Ground G.
E and A. Not directly stated, it is stated that the division date of this court in WBC number 16838, original covered by that, of by interim order that such and such had asked the state respondent to release the differential wages to the petitioner as per the L and ESI department notification. Subsequently, a detailed counter affidavit was filed by the state on 19/3/2012, but the court, without considering the counter, has filed the final order dated such and such in petition number 1683.
No, you are saying learned single judge committed an error in saying matter is covered by the judgment. Is it covered by the judgment or not?
Covered by the judgment dated 7/3/13.
Then he has granted the relief. What is the fault in that?
Yes, my humble submission that this case is not like the cases of Miller since 17838.
Yeah, that we have understood. Now we are asking you how this order is bad. Why this order is bad?
That is a different from that case, Miller. This case. Here is a case
not not applicable to this case.
Yes, I have stated in my ground.
All right, show that. You have stated is true. Now demonstrate what you have stated is true. What was the prayer? Could give that.
Yes.
Page number?
Yes, paragraph 8. Page 8.
No, that you have stated all right.
Yes.
1-3. Page 1-3. 1-3.
Regarding the
G super G. So the division bench of this court in for that the submission of documents have not been considered when delivering the final judgment. Therefore, they will be important and liable to be sent the session. No notice has to be done. They should notice. Delay is
delay of 392 days.
Issue notice on main matter as well as the accompanying application seeking delay in filing the appeal. Post after 4 weeks.
Similar to appeal under section 378(1) P. Criminal procedure against the order of acquittal judgment. This case is based on Miller's circumstantial evidence. Miller's no eyewitness.
What's the offense?
Offense is 302, 34 and 201 IPC. 34 in law. 498, 302 and 301 IPC.
Circumstantial evidence.
Yes. And Learned Trial Court is dispelling the depositions of Millers, witness Millers of PW1, PW2, PW8, PW10, and PW11 and 12 Millers, who are the Millers' parents and relative of the deceased.
What was the deceased?
Deceased was Millers. They have lived together, and I left after some 1 year of marriage. They have Millers. The husband was torturing her and assaulted again and again. They have left the matrimonial house to the parents' house. Thereafter, after some negotiation, she has come back to the matrimonial house. And after some time, and they have allegation is that they in the courtroom millers. And trial court said that it is a strangulation. Murder cause of death is asphyxia and strangulation.
Asphyxial death.
Yes. And trial court displaying that it is suicide. That does not believe that they have only ground that parents has never complained before to police that they have she has assaulted by the husband. That is the sole ground. And postmortem report said that it's a death due to the asphyxia and by strangulation.
This one when there is a
medical evidence, analysis of medical evidence.
Ligature mark is also there.
Yes.
Ligature
mark is there.
That mark 4 into 1.5 inch, 4.5 inches.
That is suicidal.
Huh?
That is due to hanging man.
No, that's where the learned court, the learned judge has dealt with that this can only happen in case of, you see, the evidence is that it is homicidal. So he has overturned the medical evidence. Look at para 9 and 10.
Medical evidence merits consideration. You cannot go by his conjectures.
And so the family may come to graduate 32 weeks.
13 last parameters in verse end.
Deadlines
also disposed by PW 16. In time of postmortem.
Is a medical officer.
Man.
Conducted the postmortem examination over the dead body of the deceased 18/1/21 and STH signed so along with Dr. M.S.Sahoo. In course of trial, he proved the postmortem report prepared by them, which was marked as Exhibit 6. It was deposed by him that at the time of conduct of postmortem examination, they noticed that the face of the deceased was cyanosed with both eyes closed, the mouth was semi-open, and the tongue was protruded.
Yes.
There was presence of bleeding from the nose and mouth of the deceased. On further examination, they noticed presence of a transverse ligature mark below the thyroid cartilage. It is 4.5 inches. Modi's medical legal jurisprudence says it is not a case of suicide.
Yes.
Take out material referred to Lloyd's medical legal jurisprudence, but generally Modi's medical legal jurisprudence is the standard book which he has to act upon. Not a case of suicide.
All the evidences which have been deposed, all the deposition which they have relied on, their case, that is PW 8, PW 5.
So anyway, it requires consideration. No? She was pregnant also.
Yes,
PW 5 and 8 is relative of blood practice.
She said pregnant.
Yes.
But what the postmortem report said?
So 35 weeks.
32 weeks.
32 weeks fetus.
Yes.
Fetus.
Yes.
It requires consideration.
All the evidences says that.
A case of circumstantial evidence.
No, he was no. All the evidences, all the deposition says that he was not present at this spot. He had been to outside. He had been to a
plea of alibi under 11. You have taken up is true, but requires consideration. Plea of alibi, always husbands will take a plea of alibi. That requires consideration.
Only one evidence, one deposition. That is PW 8, who is a child of 10 years.
So what? The child witness is also a worthy witness one.
His evidence says that he and the accused both had been to a sports event from the morning and returned in the evening.
Let us see. That child says what has been told to it. Let us see. It requires consideration. How these matters are admitted here.
It is concluded from delay and
delay, man.
Delay.
There is delay. They are not mentioned.
Delay is condemned.
No.
Yes, delay is condemned.
Condoned by order dated?
I don't know if I received.
You may not know, but it is order.
1/5/25.
Just a second.
Order number 2. I'm not good acquainted with this kind of this one.
Yes, on 1st May 25, that is delayed condition.
It's a delay in filing the appeal is condoned. Delay is condoned.
Be aware, Mr. Das.
Your awareness or not being aware makes no difference to the court record.
Converted to the government appeal and bailable warrant will be issued. That is the
Since he has already appeared, so
bailable warrant. Appeal will be surrendered before the court in bailable warrant.
How long they were in the bail was secured by?
Also on bail during trial. That is a procedure, my lord.
so he has to file again for bail. He has to file again for bail.
Bailable warrant will be surrender and release. The court may also consider for the bail here.
No, that the question arises if we admit your appeal and direct them to surrender before the trial court.
Release on bail.
What are patterns here? I don't know your patterns.
Patterns at times when they are not surrendering, then only MW. But here he has already appeared. So if he surrenders, can be granted since he was already on bail for the
application has to be done. I guess. At least we will call this matter next week. In the meanwhile, you take your decision.
Yes.
All right. But it's a case for admission. Heard in part. Call next week. Now we'll say at your request. We'll say that we are adjourning this matter at your request. Call this matter next week. Bring Modi's medico-legal jurisprudence.
Yes.
It bit in variance with Lloyd's jurisprudence.
Things are complete. This matter is right. Final hearing.
Final hearing.
Yes.
25. What is the matter?
Well, on the last occasion, before the earlier bench has provided a couple of convenience compilations. That is not there on record. And
no, what is the matter? Tell it in a short, Brandy's brief.
Well, so I am the Odisha Public Service Commission. I issued an advertisement for recruitment of dental surgeons.
Dental surgeons.
Yes, ma'am. And the examination scheme is that a 200 mark MCQ examination was held, multiple choice question. No negative marking. The respondents gave the examination, several persons gave the examination, and finally results were published. The respondents did not secure the cutoff mark. The marks secured by the last selected candidate. So therefore, they were not appointed.
Others were.
Others were appointed. Then we published the answer key after the appointments were made. Yes, ma'am. And several allegations were received that my answer key was wrong. So I gave a mandate to a second expert committee, which examined the representations of the respondents and several other candidates, and found that 15 answers
out of
200 given by the first expert committee of the OPSC were wrong. In my lords, what happened is when the answer key changed, the marks of all the selected candidates also changed. Upon a direction from this honorable court, I implemented the second expert committee report in part in respect of the respondents.
Second expert committee was constituted.
Yes, sir. The second expert committee which found that 15 answers were wrong.
The first committee?
First committee, well, it's the appointments were made on the basis of the first committee, on the report of the first committee.
Second committee was by direction of the court.
No, it was suo motu. But there was a direction from this honorable court to implement the second report,
which found 15 answers to be wrong.
Wrong.
What should be done to that?
Now, what happened, Manoj, when we implemented the order, out of the entire batch of respondents, one person was able to secure
marks more than the last selected, more than the cutoff mark, the new cutoff mark. The learned single judge holds that the OPSC had no jurisdiction to change the cutoff mark. The question of law that is before your lordships is that my submission, my lords, that cutoff mark is not something which is fixed by the OPSC. It is a consequence of the concept.
The consequence of the evaluation process.
So it is only the marks secured by the last selected candidate. And if the respondents have not...
Single judge proceeded on the assumption that you did it.
That I did it. Yes, ma'am.
It is only consequential.
It is only consequential. That I will demonstrate to your lordships.
Permitted, factually not correct.
May not be, but we will fix a date. On that date, we can argue.
Very
if
well.
you are ready now, we will hear you.
I'm ready.
Ready?
Three occasions, this matter has been heard.
No, not by this bench. So it will be a fresh matter for us. I mean, at least for me and
Yes, fresh matter.
Ready.
We have fixed another date.
Anything today also I'm ready, ma'am. Whenever
You are ready. If ready,
the senior,
No, my
the senior should
I
take
got on to my learned.
Yes.
whichever.
In fact, today it has been listed, posted for delivery of the orders. But unfortunately, the bench has been changed. I am ready to argue before this honorable court. Preferably next week, any date, your lordship.
Choose a date.
23rd.
Call on. So this date is chosen by learned advocate appearing for the answering respondents.
I'm ready.
Other than that day, next day, then no adjournment will be. Request for adjournment shall not be fixed.
In appeal, instance of the husband challenging the impugned order passed by the Royal Families of Dhenkanal under Section 9 of the Hindu Marriage Act, filed by the yes, Your Honor. Filed by the wife for respondent here for external conjugal rights.
Passover at this day.
Lordship, pursuant to the order dated 8 May 25, I have filed affidavit, one affidavit, compliance affidavit.
What is this?
So, e-filing, getting further is the eligible for the scholarship or the
You are for respondent.
Yes, state respondent.
Which order?
Yours, 8 May 25.
What's about the date?
Is that? Yes.
Five 25.
Yes.
Despite the direction to disclose the deficiency in respect of You were directed to file the affidavit. First time you did not file the affidavit. One more opportunity was given to you to file another affidavit. You did not file. Have you filed affidavit? You have not. Then you were required to appear before the court in person, your client. Very good.
Direct
State officer.
Yes.
Okay.
I have filed affidavit. That affidavit.
You have filed affidavit now.
Date.
Today.
So today you are filing.
By pen.
Only one copy. No, not two copies.
Yes, I have given.
Since he has
Hard copy.
E-filed.
Lordship, I have given hard copy. The Lordship took the hard copy.
No, you have to serve.
I have
You have to serve on the other side.
So she has to take
Yes,
inspection.
time. Scan for your update today. E-filed also. You have filed E-filed, so you can easily obtain it. Section has given you, direct section. What's your name? You are on record. Sorry? Miss R. Singh for the petitioner. Mr. Mahanti, AGA for the state appearance. The counsel for the state, when the AGA for the state refers to the order dated 5/5/2025 and submits that in compliance of the state order, affidavit on behalf of opposite party number 4, or opposite party number 2. Himself or on his behalf somebody has filed. On behalf of OP number 2 has been filed, sworn to by the
Sangamitra Das.
designation.
Deputy Director, Scheduled Tribe and
The Deputy Director, Scheduled Tribes and Scheduled Tribes Department.
minority and backward classes welfare department.
Yes.
It is submitted, the state affidavit is filed today in court. A copy of the affidavit is served on the learned counsel appearing for the petitioner. The learned counsel for the petitioner seeks accommodation to obtain instruction in response to the affidavit. The affidavit shall be taken on record, scanned copy be updated. This term? Yes. No, don't say, you must follow the code. Always don't, take this opportunity. Always, it is an opportunity for you to argue. So, this of the, how much time you require?
1 week.
He's seeking 1 week. This on 30th of June. And the 31.
Yes.
There is a small mistake in my joints. So I filed an application for amendment. I think my amendment will not have any objection in that. In my description of my presentation, IA is there.
Rejoinder to their objections.
I have filed the rejoinder. In the rejoinder, there was a clerical mistake.
High Court notes it's not there. But there. The rejoinder is there. Counsel rejoinder is there, but beyond that, it's not there. I want some amendment.
Yes. Are you ready in the matter?
I am.
Brother, are you ready in the matter?
The learned senior is saying that is trivial. It's a mistake. Will you obtain instruction or will allow the amendment?
Last time recently copied like that.
So I'll give him some time. He seems to be uncomfortable. He has no idea.
Doesn't matter. Just I have this. In my description, there was some mistake. That's all right.
You have to go through the agenda and then go through this amendment application. What is the consequence of the amendment? You have to respond to that and tell us.
Not supposed to direct this matter to be taken upon merits, fixing a date so that
You can come prepared.
when it's a matter relating to an update.
Sudhakar Rao, Senior Counsel, instructed by Mr. A. Misra Mention the name correctly. So, Mr. Sorry, I forgot your name. J.K. Khandayat Rai, State. Now, Senior Counsel refers to the IA number 8827 of 2025, filed by the petitioner, seeking amendment of the pleadings in the rejoinder, filed by the petitioner in response to the counter of the opposite parties. Copy of the IA, said IA is served on the learned ASC to enable him to obtain instruction. On consent, lister.
I am ready. Day after tomorrow or next week, maybe. Yes.
So, list on 25th of June 2020.
Yes. We indicated that efforts will be made for disposal of them. Otherwise, again, you will think that it's only for the
With that understanding, we can. We'll remember. We will remember every word uttered by almost every counsel, although names are not remembered. Yes.
Item 32 is matter is Lordship. I just encapsulate in a few minutes by Lordship's convenience.
Ready in the matter?
Yes, ma'am. Your Lordship, although it was posted for final hearing, there are certain development.
Yes, in fact,
in view of your Lordship's direction. So that is what my learned senior wants to place. Let him place.
Then I'll just take 5 minutes of your Lordship.
How much time you may take for this matter?
I'm going for full-fledged hearing because there is a direction in the interim for the principal secretary to decide the issue with regard to the subject matter of the rate application part with regard to affiliation. But that's why I'm excited to brief your Lordship.
No. If you take more time, we can ask your friends to go for a coffee round, tea round, unnecessarily waiting in the court.
5 to 6 days for appraisal Lordship. Thereafter, because the state government has in the meantime issued a letter for I am fixing a date of hearing that I need to appraise the Lordship.
What was the order on 15/5/25? Which is that? That's into
17, order number 5.
Order number 5.
Yes.
Number 5. Third Nanda. Say so. What is that MLU?
There are 4 relevant
for fresh application, which is against the mandate. This it's so next page. The short grievance is, once affiliation is granted, whether its renewal is required in the scheme of the Act or it endures for eternity.
Yes.
That is the question.
It's subject, in fact, my submission to Lordship is, I'll just start from the commencement at the threshold. It says, this petitioner college is unaided private law college. It was established in 1981, way back. Thereafter, it got permanent recognition and permanent affiliation from the government. Permanent affiliation was given by Utkal University then.
Recognition is given by whom?
Government.
Government gives recognition and university grants and affiliation.
Utkal University granted permanent affiliation with affiliated students. Now, my submission before Lordship, this is a conferred status by the university that this college has the right to get a permanent affiliation and with an affiliated student strength of so and so. So that was bestowed upon my college. Thereafter, in 2004, the state government, combined, took out the inspection of that college and said, no, it should not be, because the initial grant of affiliation was for 320. Affiliated students was 320.
Intake capacity.
So when they carried out the survey, they are slightly lacking in the infrastructure that may be brought down to one.
It was reduced.
Yeah, it was reduced. That order was challenged before this honorable court. Now, this honorable court directed after detailed survey and the committee visited and everything that came out that 240 should be the fixed strength rate. In view of the infrastructure they can have 240. That legal educations came in, legal education rules under the BCI Government of India rules. That came in 2008. We in the meantime had already got a UGC recognition under 2F and 12. And it was one of the oldest premier institutes catering to the entire area of Puri and the districts adjoining. Now in 2021, when the state government issued a notification that those law universities, law colleges which are under the Utkal University, that may come under the umbrella of Madhusudan Law University.
A separate law university is there.
It was created by way of a notification. That is there in the Annex 8. So when that notification...
Whether is there any statute which establishes universities?
This power is exercised by the Lordship. See that notification.
No, I'm asking a question.
Why not?
Universities are generally established under Universities Act, State Universities
Yes,
Act.
Odisha
Generally. This law university is established under which act?
This was initially under the Odisha Universities Act, which is now governing the field. That is governing the field. Then it was Utkal University. Subsequently, under the Odisha Universities Act, this MLU was constituted, Madhusudan Law University. So in 2000...
Under the same act?
So your
Yes.
answer is the same act?
Yes.
Same act.
Yes.
Okay.
That governs the field. So when that was constituted, immediately when the MLU came into existence, I'm sorry, I'm using the abbreviation, MLU.
We should be short is true,
Yeah.
but too short is to be cruel only to a person like me who comes from
As the
other
new university, as
Yes.
the new university, which is the Madhusudan Law University, that immediately in a passage of few months, they started issuing notices to all these private law colleges, asking them to apply afresh.
affiliation.
Yes, affiliation. So all these private universities, they approached the state government. They said, we already have permanent affiliation. We have already recognized, we have seen the infrastructure, and there is
You need not go for a fresh affiliation.
no reversal of that unless if there is any violation or there is any discrepancy pointed out. So accordingly, all the universities, when the universities, colleges, private colleges, they represented before the state government. State government came up with a clarification which is under Annex 10, saying that these are transferred affiliations, and only those ones which are provisionals or those who do not have affiliation, they will fresh apply to the...
So you are saved.
Yes, that is my case, my lords. My prayer is in fact that my affiliation is a permanent affiliation. Unless the records...
Take us to the provisions of your statute which governs the grant of affiliation.
Yes, I have filed...
Let us see how they are worded.
Filed the memo which is flag marked. Your Lordship's convenience, all the statutory provisions I have given for your Lordship's convenience. That means that...
There is one judgment of the apex court relating to affiliation.
Yes.
Have you cited that decision?
No,
Once affiliation is granted, unless the statute under which it is granted specifies the period, it will endure for eternity.
In fact, not only your Lordship, there's a Kerala High Court judgment which I filed that's on record. It's on a flag N. Your Lordship seen that flag N.
Why is such a bulky file for such a small issue?
My lords, that is the reason, my lords, I needed to reach your Lordship. They have been, as the matter is subject before your Lordship, they have been time and again filing issuing fresh letters to the college.
All you have produced them.
Yes, I had to because initially they stopped.
I understood the point. Go to the provisions which govern issuance of affiliation.
That is there before Lordship under
which is the section?
Flag F. Flag F.
Yeah, which is the act flag we want?
Flag F dash.
Act. This
Flag
is
F.
Flag F. No, statute, act, Orissa Universities Act.
Yes, I have all compiled and...
You have compiled everything?
Yes, yes.
Okay, that's good of you. Yep.
You know,
that section?
Page 17 of that compilation, that is section 19.
19. Any two members of
the syndicate or director will be
forward a proposal in the that a college be deprived either in whole or part of its privilege. That is deprivation of privilege.
Privileges. The syndicate shall cause an...
Whether privilege includes affiliation also?
Yes, ma'am.
Is it defined that way?
Well, that is covered. I mean, if your lordship sees the
Whether affiliation is defined.
definition of affiliation, affiliated institution means a college as
No, affiliated institution.
Yes.
What is meant by affiliation as such? Affiliated institution means an institution to which affiliation is granted.
Yes.
But beyond that, it does not take us.
No,
What
it's
is
not-
meant by affiliation?
There's no specific definition for KCA. In that Orissa Universities Act only says with regard to affiliated institution.
Which section provides for grant of affiliation?
18 initiates the process.
18.
This has to be read with, in fact, there is Orissa University's first statute
Statutes are promulgated under this act.
under this act. That also I've given in the compilation.
Where is the word affiliation in section 18?
In fact, that's the process they follow. The Orissa University statute, which
It speaks of, kindly see, no educational institution shall be admitted as a college.
yes.
Therefore, I asked what is meant by affiliation.
Affiliation as such is not defined here. But if you're not
Take out, any youngsters, take out the judgment of the apex court where it defined what is meant by affiliation. Any youngsters can do this. Go to Google out that judgment. Supreme Court defined what is meant by affiliation. Do you have words and Supreme Court on words and phrases? Ask our librarian to come here. By Surendra Malik, Supreme Court on words and phrases. Ask him to bring that judgment, that compilation. Affiliation is defined by the Supreme Court, 3-judgment decision of the apex court. In at least 3 judgments, they have referred to that. Which is that judgment?
That judgment I'm immediately not getting, but the basic
No, it's there.
context is there. Can I read out it?
Are you reading the judgment?
I think it's an extract from that because
Yes, right.
in the context of Supreme Court, affiliation generally refers to relationship or connection between an individual or entity and a particular organization, group, or cause. This connection can be formal, like being a member of a political party or being associated with a specific university, or it can be more informal, like having shared beliefs or values. In legal context, is often relates to formal recognition or association of an institution with a larger
No,
body. Like
those words are not there in that judgment. The judgment is very specific.
Maharshi
Dayanand
College versus
State of Madras,
No, it's Himachal Pradesh.
Himachal Pradesh.
2017.
Which is that paragraph?
Affiliation enables an institution to present the students for university degrees.
That is, once your institution is affiliated, in degrees, diplomas, and PhDs, awards, titles, they are granted by the university to which you are affiliated.
My lords.
That's the meaning. But the word affiliation is missing in section 18 and 19 also.
Yes, but in the definition they have given affiliated institution.
Means what? Read.
Affiliated institution means a college or institution affiliated to a university with whether in whole or in part.
That's the problem. No section which refers to affiliation, the word affiliation or affiliated institution in the whole of the statute.
In fact,
Yes, ma'am.
Orissa University is affiliated
institution. Affiliated institution, he read. Affiliated institution means an institution or part of the institution which is affiliated to the university. That does not take us anything.
Even the Orissa first statute, which I have also given to your lordship for your convenience, that also starts in that.
No, your submission is the pith and substance of your submission is once affiliation is granted,
It's a comfort.
merely because subsequently some university I have brought in, that affiliation will inure to your benefit, even when you are brought under the aegis of any university. That's the question of law.
My lord.
What the Kerala High Court said?
Kerala High Court, if your lordship will place that flag end, it is with regard to that affiliation part, it says, may I read out? Flag end, it's
N.
And towards the end, section 19 I have given there, thereafter the judge.
They are insisting that you should take fresh affiliation. Why this question arose?
They are asking for fresh affiliation.
Fresh affiliation.
We have given application for transfer of affiliation.
Fresh affiliation you are asking under which section?
When this new university was constituted,
Yeah.
that order itself says all previous affiliations are ceased. And with that, yes, madam, I have filed in the document.
Annexure 8, madam.
Lordship, may kindly see.
Annexure 8.
Eight.
Madam, may kindly see my counter. Page 25, Annexure A by 1 series, my lords.
No, since we are in the petition, it is better you also refer to Annexure 8.
My lords.
So we don't have to click through the pages again.
Correct. My lords.
You are agreeing, right? It is Annexure 8.
My lords.
Then why you are voting?
In supersession of the Annexure A1, page 23.
49.
29.
Read petition 49.
49.
49.
In my lords, yes, ma'am, that. Yes.
Thereafter, Annexure 10. Hey, yes.
Can I read that?
1 second. 49.
Notification.
Page 49 you have to run. You have taken 18, huh? That one. 49. Kindly face.
In supersession of this department, notification number so dated 4/3/2020 and notification number so dated 11/6/2020, the state government do hereby alter the territorial jurisdiction of all existing universities of the state and establish a new university called Madhusudan Law University at Cuttack by upgrading Madhusudan Law College, Cuttack, with effect from 28 April 2021. All existing government and private law colleges, except the constituent colleges of different universities of the state, shall cease to be affiliated from their respective universities from 28th April 2021 and shall stand affiliated to the Madhusudan Law University from that date. The said Madhusudan Law University shall have jurisdiction, save as aforesaid, over all the law colleges of the state.
What is meant by this?
Yes, minutes. What we are humbly submitting, minutes.
No, what is meant by this?
Meant by this minutes, the previous affiliations of the
They will go.
and they will stand affiliated to the new college.
It is automatic affiliation.
Yes, my lords. That is what.
Correct.
But what then, my lords, we should notice, because my lords, your lordship would appreciate that the university needs to know the strength, the infrastructure of the colleges, those who are automatically.
That information you could have sought for.
That is what.
Why affiliation?
Well, that is what I'm submitting, minutes. That is what I'm submitting, minutes. That is my knowledge senior submitted his pardons. Now, what is the case exactly, minutes? The university issued notice to all the colleges.
You must understand the court's query.
Yes, ma'am.
Because is it your case that under Utkal University, the Utkal University was not aware
My lords.
of the facilities till it was affiliated?
No, it was, my
You
lords.
see, it says shall stand affiliated.
My lords.
So that is how the question was asked to you, that under which provision you are asking for it.
My lords.
And all this discussion, the definition of affiliation,
My
whether
lords.
Going by simple Wren and Martin grammar book,
My lords.
this means affiliations that are already granted
Yes, my lords.
will continue
Yes, my lords.
with you.
Yes, my lords.
That's all.
My lords.
Annexure 10, the government clarified that.
Okay. Go to Annexure 10. To the same effect.
Yes, yes. Okay. That's what I said. All the private colleges that approach the government, they have to government issue.
Page number?
Page number 56.
56.
It's a paragraph there.
Working. That way.
Paragraph there.
I should never touched any computer for anything. I never felt the need also.
Paragraph which starts therefore.
Which paragraph you are? Therefore, the respective parent university are hereby advised to transfer the
Transfer.
fee deposit
Keyword.
money, etc.
Transfer the affiliation.
You are affiliating university immediately under intimation to the colleges concerned. The new affiliating university advised not to demand deposit sides are presented and also advised to issue that no objection certificate in favor of. Yes. Now, what is that order you are aggrieved by?
Matters. In this writ petition, Annexure 12, they
12. 1 second. What it says?
It's suddenly, in fact, they included me and other private colleges in their list of affiliated colleges. 3 years they remained silent. Suddenly, after the admissions were over in 2024, they came up with this letter, all of
saying
that you're pleased to grant provisional. If your lordship see, reads the first line, it's page 76. Out of the blue, the Vice Chancellor has been pleased to grant provisional affiliation in favor of so and so, with 240 seats for the academic year so and so, to which regularize the affiliation for 3 years, and therefore 3 sections at the rate of 60 each, academic year 2024-25 for the above course.
Yes, brother, how can you sustain this?
Well, after the university was formed, my lords.
Can you outgrow that? You have outgrown that Annex 10.
No, my lords, we are not demanding.
We are
also admitting.
Either you refer to the statute.
Yes.
Do something.
Yes.
Point out the irregularities or whatever you want.
Yes, man. That is what.
But you can't suddenly you have outgrown and you say that it is only provisional affiliation.
Well, that's why I'm saying.
Then you are trying to interpret Annex 10.
My lords.
That because it stands affiliated. I think the language used is stand affiliated. Very simple.
Yes, my lord.
Brendan Martin language.
Yes, man. We don't dispute that. Only dispute is that, my lords, they have to make applications.
What for?
For, my lord, syndicate decided. Why, my lords? The syndicate decided, new university, syndicate decided the strength of the student for each class will be 180. Subject to satisfaction of infrastructure and teacher strength as per the statute.
Follow the procedure.
Yes, sir, we followed the procedure.
Yes, straight away said that your affiliation is provisional.
Let me kindly see, my lord. We have issued letters.
You are saying so. No, you have not issued this letter. Annex 12.
Before that, what we have done, that may be permitted to. Before issuing that, what I have.
Please concentrate on the language you have used.
Yes, but alter the nature, duration, or condition, structure, texture, and architecture of the notification. You cannot alter it. It's a statutory notification.
Yes, before issuing this letter,
what all happened before issuing that is irrelevant to us. End product is our focal point.
Yes, ma'am.
The end product affects his rights because he was granted affiliation and the notification at Annex 11 specifically said the affiliation would continue with the university.
Yes, ma'am.
That you cannot injure. That's a status. The one judgment in Supreme Court said affiliation and recognition or status from whom rights emerge.
Yes, my lords.
My rights emerge because I am a husband.
Yes.
My rights emerge because I am a wife. I am a teacher. I am a judge. These facts, title facts, give rise to certain rights. Those rights you cannot cut short except with the authority of law.
My lords, that is what I will satisfy you.
Yes.
My lords, we do not say that they are de-affiliated or their affiliations have been withdrawn.
You have said.
My lords, that
you made that affiliation provisional affiliation.
Yes, my lords.
How can there be a provisional marriage?
My lords,
that's what we are asking you.
Yes.
See, the basic principle, foundational principles are a man can do, a natural person can do all that is not prohibited by law.
My lords.
A legal person can do all that is authorized by law.
My lords.
University is a legal person.
My lords.
Do you agree with me?
Yes, my lords.
If it is so, where is the power to you to cut short the affiliation, alter the nature of the affiliation, and do something contrary to scheme of the act?
My lords, I have to answer to it.
Yes.
So far as their affiliation is concerned, my lords, we have said, my lords, that is with relation to 240 strength, my lords. And that 240 strength which flows from the judgment of our direction of this honorable court.
Where you are just adding those words to your speech. To be fair with you,
my lords,
you do not refer to anything.
My lords, I will.
Please concentrate on the impugned order.
Yes, my lords.
Because if you add on whether it is 320, 240, then it becomes a kind of expedition where we do not know even.
That is the
Mr. Bera, his contention is not that we should be allowed 320, 240.
That is his contention.
No, that's not. Then with greatest of respect, that is not his contention. You may go by, whatever the affiliation was with him from Utkal University. The question is whether you can alter it.
My lords, sir.
Can you make it temporary or any kind of other? Say that.
Under which, we'll come to it. Sorry, we are calling upon you.
No.
Anyway, see, brother, see the conditions.
Yes, ma'am.
Now, what are these conditions? These are the conditions which an institution aspiring for affiliation has to comply with.
Yes.
See this condition.
My lord. The
college must appoint adequate number of faculties immediately as per science.
Yes, ma'am.
That you have?
Yes, ma'am.
Faculties you have?
In fact, they don't have.
They don't have.
No, that is what I wanted to show two letters, ma'am.
Let us see on which point we are in disagreement.
I have replied to them.
College must appoint at least 2 associate professors for the LLM course. Do you have that?
Yes.
1 second. Number 3, read it. Classrooms must be maintained properly by installing whiteboard. This is law college?
Yes, law.
You should have put one more sentence here. All students should read law. And taught law. Teacher should teach law. Yes. College must seek the BCI recognition. BCI recognition you have got?
Yes.
Academic year. You are asking them to get BCI recognition again. What's the latest judgment on BCI recognition now? About 1 month back, Apex Court judgment came, na? What it said. Google out. Why are you not updating? Why Bar is not updating?
Yes, I'll do that.
May I submit one? This was...
If you want real betterment of the law college,
yes,
you should have followed the law simply. Followed the law and tried to improve the conditions. You have rather led them to go to the come to court and question your action. You follow the law.
Yes.
Because if you want law to be taught, you should also follow the law.
Yes. As per the statute, they don't have. That's why inflection.
You do it, but you have converted. You have converted the affiliation because basically you don't have an answer to that perhaps. You can have a state answer that the university when it changes, the best answer could be. It's a hypothesis.
Yes.
That once it is Madhusudan Law University, the law is different.
No, Under
Utkal, it was permanent. Under Madhusudan, it is temporary. Provisional. I'll start getting. That's the best argument you can make.
I very much appreciate that. There is no concept of permanent affiliation so far as the Odisha Universities Act and statute.
But there is a concept of provisional affiliation.
That is affiliation, no provisional affiliation. That is only affiliation. Why provisional?
No.
That is what I want to answer.
You are wrong. With due respect. Apex Court said,
yes,
power to grant affiliation includes power to grant provisional affiliation. There is such a judgment.
Yes. That is in your favor.
Referring to section 21 of General Process Act. Apex Court said that. No, we are simply asking you. The requirements, if we read Annex 12, page 76.
Yes, ma'am.
It gives an impression that you are insisting upon fresh affiliation because these are the conditions which are generally prescribed to an aspirant of recognition or affiliation.
I bowed on. But here what has happened, that is what I have filed in my preliminary counter. After the formation, all the law colleges, those who have taken to the fold of Madhusudan Law University, made an application with regard to their student strength, the teacher faculty strength, and the infrastructure in order to maintain a record at least.
Then those we can understand.
They did not give any application.
Did you ask for that?
Yes, Lordship may kindly see.
We'll come back. Anyway, when judges are in your favor, do not permit the mind.
I bowed on.
Yes.
Lordship may see page 27 of my counter.
Annex
27.
Annex
B by 1.
B by 1.
This is a letter which was issued in 3/8/2024 and the university was formed in 28/4/2021. From 21 till 24, they did not make any application or any communication.
Where is the requirement of application?
That is what Lordship will see. May kindly see, page 25.
Page 25.
Yes, madam.
You are making us to jump from page to page.
I'm just answering your Lordship's query, ma'am. I'm sorry for the creating trouble, ma'am. I'm answering your Lordship.
after the formation of the university, this notification was issued to all the law colleges to make applications for affiliation through proper procedure. But now, the Lordship will put me this question.
See, again there is a defect.
Yes.
It is valid for the academic session 2021-22.
Yes, my lords.
Again, why this university? No good advisors to the university for the next academic session. In fact, when George Bernard Shaw came to Bombay University, he said Bombay University is known for the height of its tower and depth of its ignorance. It appears it applies to your university also, partly.
Well, practically what happened?
So, Subhera,
Yes.
please read and reread the notification.
That I bowed down.
No, why should you bow down?
Because
Read, simply read. You don't have to bow down because you have to read.
Yes,
We bow down to law.
Yes.
well, that is what falls from your
No.
lordship. There is no
So suppose, let us assuming you have
Yes.
all these powers.
Yes.
Then kindly so.
Yes, well, I'll show.
So don't go on an empty. Absolutely no basis, no reference to any law, any statute, any rules.
Law university
Yes.
is not university unto law.
My lord.
Not university cannot be law unto itself. See, kindly come to page 25, which you are banking upon.
My lord.
See, all the law colleges are required to apply for the affiliation through proper procedures. Why? What's your power?
The syndicate decided.
Your umbilical cord
Yes, ma'am.
itself said
My lord.
the colleges stand affiliated to university.
My lord.
If that is so, what is affiliated
My lord.
cannot be re-affiliated unless there is a provision.
My lord.
No, we are taking lot of time, small matter. Many law students may laugh at us.
My lord. Lordship may give me one opportunity.
What?
Because what has happened, my lord, in statute, my lord, what they do not, as per the statute, my lord, we inspected them, and they do not possess minimum requirement which we intimated them to fulfill. They did not fulfill, and from 2021 to 24, they did not make any application, my lord, for at least, my lord, informing their.
No, you did not ask for.
We asked for it.
You asked for affiliation.
No, my lord, that is.
Then at least this will go.
This will, yes, ma'am.
This will go. Then whatever information you want, once it is affiliated,
yes, ma'am.
you have a kind of power
My lord.
which you can exercise.
Yes, ma'am.
Because affiliation is only a privilege.
Yes,
You can tell them, the teacher should be like this.
yes,
Your student should be like this, reading room like this, library like this.
Yes.
These things you can do.
yes, ma'am.
But affiliation as such you cannot make.
Affiliation we are not contesting. We are
We'll
saying
record your submission.
Lordship
That you will treat affiliation granted to them
Yes, ma'am.
as being intact.
Yes.
And the university shall not insist upon fresh affiliation.
No minutes.
Huh?
Yes, ma'am.
We'll record this.
Lordship, that is
However,
we'll find
whatever
affidavit
other
to-
requirements are there,
student strength minutes.
whatever,
Yes.
those things are always with you. Always.
Yes, ma'am. That Lordship, that is what my first submission from the first day.
Anyway, with this you are in agreement now.
Yes, ma'am. So
That
far as-
all these documents
yes, ma'am.
shall be construed as not requiring the college
For fresh.
applying for affiliation at all.
Yes, ma'am.
College shall be treated as having been affiliated and having been continued to be affiliated.
Subject to the conditions.
For all purposes. However,
Yes, ma'am.
the university shall be entitled to take all other measures as are permitted under the Act and the statutes.
19. Well,
We do not know. We are not sure that 19 would apply either. Your 19 does not use the word affiliation.
yes, ma'am.
19 is an adjunct of section 18. 18 and 19, they are kindred provisions.
I'll assist you, Lordship.
Anyway, he is agreeable.
Well,
You mean to say university should never control you?
No.
They will be entitled.
Absolutely not. I'll never say that. I'll never say that. My lords, what? In fact, I'll just bring you like a lordship's kind. Why your lordship at the initial stage asked me that why so many affidavits have been filed. In fact, if you
No, all these things what we don't want to unnecessarily. Your grievance is
2 lines from you.
no problem. We will have you 10 lines. But before that, if we are addressing your grievance, number one, he is saying what all has been challenged before this court shall not be construed as disruption of affiliation. and shall not be construed as requiring you to make fresh application for the grant of affiliation. That will record and dispose of the matter. However, the suzerainty control other things as are provided under the Act, because it's university.
Yes.
It is entitled to look it. It is entitled to look at whether college is being run in accordance with law.
Yes.
These things they are entitled to.
Submission is
Fresh actions they can.
natural justice.
That's what. That
Because
they will do.
they got 2 lines of submit. What they did, in fact, after I came up before the Lordship, they first stopped my students from appearing at the examination. Then I came up before this Honorable Court. Interim order was passed. My the students were allowed to appear. Immediately thereafter, they did not publish the result. Then again, I filed an additional affidavit that my student results have not been published. This Honorable Court protected me and directed them to release the result. Immediately thereafter, they came up again with another letter. That's what they've been doing. For the fresh session 2025-26, your affiliation has to be applied fresh application.
No, he has said that you are only repeating unless.
Now, the next part comes in, again another letter, which another additional affidavit is brought to this Honorable Court's notice, that your student strength is reduced from 240 to 180. My lords, when my prayer in the writ application is with regard to my affiliated student strength and my affiliation with regard to the granted by Utkal University, which is now continuing, has been transferred.
Now, are you agreeable? See, we have many types of judgments. One, we have heard you, we have heard him, we'll pass the judgment. Another pattern is both stood tall, you are taller, though he is not short. So, both you stood tall at the bar. At the bar, you stood tall, regardless of your physical tallness, and said to the court that all these documents should be construed this way, with all fairness, having argued the matter. Can I say that? Or you want an order on merit itself? Because you are
two submissions which I
you have not completed your submission.
I was answering your lordship's query. What has happened? We have
First submission is
objection on the maintainability at the behest of the present petitioner.
Why?
Because the present petitioner, who represents the college as principal, has already crossed the age of superannuation. The government, submitting.
As on the date he filed the applicable petition.
Sorry.
As on the date he filed the petition.
Yes, my lords.
He was no longer principal. Or he continued to be principal.
He could be principal in
even after the date of retirement.
The government, state government has
guideline again. That's the bull on horn. Whether you dispute that he's the principal, you straight away tell the court that he's not the principal.
That is why I will take your lordship to Odisha University's first statute.
That
with
may be true.
Conditions true.
That may be wrong.
Yes, my lord.
But he continues to be the principal. Even after the date of retirement.
Why we are challenging?
Superannuation.
The statute says, the conditions for continued affiliation of the lordship.
Your statute cannot override.
Yes, my lords.
The notification issued by the government establishing the society, the university itself.
No, I'm not in that.
Yes.
Statute said what are the conditions required to be fulfilled by a college for continued affiliation?
For continued.
Yes, my lord.
Where is the power to issue that make the statute?
Mr. Behra, it is the case that since the principal has attained the age of superannuation, we're withdrawing appellation.
No, my lord.
So then why you are arguing on this?
Why, my lord? He has to satisfy the syndicate of the new university that they have not done.
Mr. Behra, don't make hypothetical submission.
No, I'm saying on the statute.
Suppose you have issued him notice.
Yes,
that look, you are attained 61 years.
Yes,
the college is to affiliation to be withdrawn on this ground. Then he answers, or the principal answers whoever. He means the institution. So that is besides the issue. It is only that whether you can withdraw the appellation, ask for certain compliances, post you have been instilled as an institution or holding the power to university, just like Utkal University or predecessor. So can you have that power of withdrawing appellation better than Utkal University had, which still exists?
No, we are not withdrawing, Melons. Only thing is that the new college which has been...
No, the last query was whether you will, your submission will be recorded or by answer on merits. My lord was asking you that. Because both of you argued well. You have argued well. Stood tall at the bar. That was
one line. The conditions for the continued affiliation has not been fulfilled by them. So therefore, this provisional affiliation term was used considering the career of the student, those who were admitted after the formation of the university, new university.
So that is the reason why we have used the provisional affiliation. And the condition has not been fulfilled till date. That is what, if your lordship will...
So, Bera, this has never happened in the state of Odisha. There is a technical university.
Yes, ma'am.
There is a medical university.
Madam.
This is first time this is happening, that you withdraw affiliation and then ask for compliance. Because if you want to really, concerned about the law teaching and
Yes,
the condition of the university of the students, then you should have acted following law.
Well, we have not withdrawn, at least considering this.
Then why you are
continuing?
Then why you have issued that letter to encourage litigation?
No, Manoj.
Then why you are saying that we have not withdrawn, we have made it a provisional subject to condition? You are pointing out that his principal says he's 61 years.
Manoj,
You should have issued those notices.
Removing him or whatever way. But as long as he is there, he represents the college.
Well, he represents the college. He should satisfy the condition for continuing affiliation to the syndicate. That is the statute.
We are not agreeable with your if your statute cannot override the Parent Act.
That is from the universities, sir.
Thank you. We are allowing the petition. But your suzerainty and other things, those will
yes,
those will remain.
One more submission, Manoj. So far as the university's statute with regard to student strength, and that may be
which is that judgment which mentioned defined affiliation.
Yes, yes.
Of state of Haryana.
Mahasi Markandeswar Medical College versus state of Himachal Pradesh.
Himachal Pradesh.
Yes.
2017. Right now. 2017.
What is civil appeal number?
Civil appeal number.
Yes.
Just afterwards leave it. It's reported also.
Yes.
It's reported. I have read that judgment.
Since then,
rest of the other things will follow. And other things, other suzerainty and administration, those things they will be able to. But firstly, they will do it so that you will have opportunity. And
yes,
because during the pendency of writ application, they have issued a lot of letters and this.
All consequential things will go,
My lords.
but liberty lies with them.
Yes, my lord.
To take appropriate action to ensure that the academic standards are maintained. That's what.
Yes.
In accordance with principle natural justice, prior notice be given and
That the law university knows principles of natural justice. Even God had given opportunity of hearing to Adam and Eve before punishing them for eating the forbidden fruit in the Eden garden. Is it? The university knows that. University reads Bible also. That will make.
There is another hearing by Lordship's direction. As per your Lordship's direction, there is a hearing posted to 25th to decide that Annexure 10.
First, we'll decide this. Then
This is
it will
decided
throw.
that may be accordingly.
That becomes infectious.
That
infectious.
Yes.
That can I get it? No? Both they said like this. In fact, that is a problem to stay. And both the matters can be disposed of.
that matter will challenge that 25th.
Why?
No,
why?
Is there any another writ petition?
No. This is the writ. In this writ petition, that order was passed.
No, you said there is another matter.
No, madam. This is the matter.
Pursuant to the
Order number 5.
he is saying, sir.
Okay, before 25th.
No, madam, we're bringing your Lordship's kind knowledge that if Lordship decides, then that becomes infructuous, and the state government did not decide that. Right. One more information, if your Lordship permits me. So far as the student strength is concerned, in the entire state, the university has decided.
We are reading the card, what report was, what is that over? You see, we are not discussing that. Are you asking us to decide how many students to get?
No, madam. No, absolutely.
Then why you are making those submissions?
That was my
Coming into effect of the Lordship, just assisting your Lordship, Legal Education Rules 2008, Bar Council of India is the appropriate authority to decide the student standards of legal education with regards to student strength also.
Have you seen the latest judgment of the Apex Court?
That's 2000.
Yes, my lord.
About the 1 month back.
If you're not, this is the 2023 judgment.
No, 25. Very latest judgment. There is some inroad made. I have not read full judgment, but I appeared in live law. Latest judgment.
The Supreme, Mr. PCI is the supreme authority. They have held that our Council of India is the supreme authority with regard to decision on the 2023.
My lords. But you are not leading to our next march of law. Marches from April to May. So the June of its life. Any short matter? One small meeting we have. Any short matter? Yes, we are getting.
My lords.
The next item, lordships. Here the matter was last posted by anyone registered for a short matter. So,
Is from item 23 is not taken. If you add it to next week's.
Yes.
I think, yes.
It is not going out of the list.
No, I understand. The lordship only that I'm the wife. This court has passed the order so far as the interim maintenance is concerned. On the last occasion, the defendant counsel, the husband counsel has shown that they have filed an application for the Supreme Court. That is why your lordship has directed that by this date, they have to inform.
What happened in Supreme?
Yes, that is the thing. They are neither paying.
I'm appearing.
Yes. Yes.
It's an order for interim maintenance was passed by this Honorable Court.
Right.
That particular order was challenged by the present respondent before the Honorable Supreme Court in an acceptable. As on date, the court's on vacation, and Supreme Court's on vacations, reopening on.
Is that? Then the Supreme Court. You have vacations.
No, may kindly see the last order passed in.
No, there is an order to make the payment.
No, that is.
The payment has to be made.
No.
Because the relationship is admitted.
Look, all these points were considered on the previous date by a coordinate bench of this Honorable Court.
Then only
and the previous order was passed in this item 33 minutes.
Whether the client is ready to make payment or we should direct arrest and detention. We are ordering now, right now. But in fact,
Look, may
arrest and detention.
I submit? May kindly have a look at the last order, order number 4 of this Honorable.
Well, which is the latest order.
Look.
We are directing arrest and detention of husbands. They are taking women to drugs.
Honorable Court it will affect the subsequent proceedings.
This payment is without prejudice to contentions of the police.
And it's not a recurring payment. What do you mean by determination of 25? It's not a recurring payment of permanent alimony or pendant.
Then you need not be arrested.
Fix up the date. Fix up the date.
After July 14th, because after which the court's Honorable Supreme Court will remit the payments.
Complaints on 2 weeks over. On second of June.
So second of July.
But the similar order was passed in item number 40. It has not been complied with. That's an outstanding amount.
It will be added next week. It will be added.
All these panels were in
So why suffice? Only question of permission.
next week.
What is the other side to inform him?
Yes, my sin is there.
Period has gone.
So, Patel, you suggest that I put the court pass.
Whichever day. All right. Send.